Ei, du. Du. Ei, du. Vienas, du.
O jūs tuo metu Zoom'ą pasijungėt ar lietuvių kalbą girdėjot?
Pasijungiau.
Ei, 1, 2. Ei, 1, 2. 1, 2.
Viskas gerai, viskas tvarkoje. LT turimų dalykų. Ir dabar
Ei, 1, 2. Anglų. Ei, anglų.
Labadiena, gerbiami seminaro dalyviai ir
Good
pranešėjai.
morning, ladies and gentlemen,
Pradedame
speakers and
seminarą,
participants of the
tema
seminar.
duomenų
We
apsauga.
begin our
Visų pirma,
seminar
tai visų
on
paprašysiu
the
išjungti
protection, data
mobiliuosius
protection.
telefonus.
Please, first of all,
Taip pat
could you
tiems
turn off your
asmenims,
mobile
kuriems
phones?
vertimas,
For
paprašysiu
persons who
užsidėti
need
ausines.
interpretation, we kindly invite you to take the headphones and use them. I give the floor now to the President of the Lithuanian Chamber of Notaries, Marius Stračkaitis, for his greetings address.
Labas rytas.
Good morning, everyone.
Svečiai, seminaro
Our guests,
Man džiugu
ladies and
šiandien
gentlemen,
pasveikinti
it is a
visus
pleasure to welcome you all
seminarą
today at the seminar on data protection.
Asmens duomenų
The
ir
protection
privatumo
of
yra
data and
ypač
personal
aktuali
privacy is especially
visuomenėje
topical in our society and on a global
Tinkama
scale in
šios
general.
dienos pagrindinių žmogaus
This
teisių
human right will
svarba tik didės.
gain more and more
mūsų
importance
kasdienių veiklų yra
as more and more daily
perkeliama
activities
į
are
skaitmeninę
transferred to a
Dar
virtual space.
didesnį visuomenės skaitmenizavimą paskatino pandemijos metu įvestas
Quarantine due to COVID-19
Kadangi
promoted a more
informacijos
rapid
niekad nėra
digitalization
tokia
of society.
intensyvi,
Since the
privatumo
dissemination of
apsauga
information has
darosi
never been
vis
so intense,
jaukiau.
it is more and more difficult to preserve
Notariatas
privacy.
ši tema yra
This topic is especially important for notaries as they collect and process personal data each day because of the type of work they do. Data protection is closely interrelated with professional secrecy, one of the most essential principles for notaries. The obligation to uphold this principle springs from the very nature of notary's profession, and the appropriate implementation is an essential precondition of notary activities. First and foremost, notaries preserve professional secret in the interests of a client. The application of this strict principle is the guarantor of trust in notary. Thus, each notary must take responsibility to take care of data protection on the basis of professional secret, as well as on the basis of national and European legislation with the General Data Protection Regulation at its core. Notaries were always bound by the rules on secrecy of notarial acts. The entry into the force of the General Data Protection Regulation did not lead to radical changes in the activities of notaries. However, new requirements for the protection of personal data had to be implemented. This has become particularly relevant with the creation of the e-notary information system by the Lithuanian Chamber of Notaries and the use of the e-notary information system by notaries. The increasing number of cybercrime and cyber incidents, both in Lithuania and worldwide, calls for a particularly good assessment of information security risks and for due attention to cybersecurity. It should be noted that data protection is also a concern for notaries' customers, and the level of knowledge is increasing, as can be seen from income inquiries concerning the processing of personal data. As data protection is a process, notaries regularly learn for the proper application of the General Data Protection Regulation. This workshop was therefore organized to provide notaries with up-to-date knowledge on the protection of personal data. I wish all of you interesting seminar and productive work. I entrust the moderation of the seminar to the Data Protection Officer of Lithuanian Chamber of Notaries, Ieva Mikaliukštytė. Thank you for your attention.
I thank the President of the Chamber of Notaries for his address, and I give the floor Secretary General of the Council of the Notariates of the European Union, Mr. Raul Radwa. Mr. Raul, the floor is yours.
Good morning, ladies and gentlemen.
Labas rytas, ponios ir ponai, gerbiamasis prezidentė Mariau Stračkaitė, Lietuvos institucijų atstovai, profesoriai, lektoriai, kolegos. Šiandien man didelį garbė ir aš džiaugiuosi, turėdama šią galimybę pasveikinti jūs ir kreiptis į Lietuvos notarus, taip pat į kaimynus iš Latvijos, Estijos ir Lietuvos. Labai džiaugiuosi galėdamas grįžti į jūsų nuostabią sostinę Vilnių, kuri šiomis dienomis yra baltai pasipuošusi ir būti kartu su kolegomis iš Lietuvos notarų rūmų. Šiandien notarų taryba yra labai svarbi diena, nes oficialiai pradedame veiklą skirtą notarams. Pagal mūsų mokymo programą norėčiau padėkoti Marijui Stračkaičiui ir jo komandai už asmeninį ir profesinį įsipareigojimą organizuojančiai pirmąjį seminarą Lietuvoje, mūsų Europos dalyje, jeigu galėčiau tai pasakyti. Norėčiau keletą žodžių pasakyti apie projektą ir jo kontekstą. L.N. yra sutrumpinimas pavadinimo ES teisė notarams, notarai ES teisėjai. Ir ši ES notarų tarybos programa yra skirta notarams ir finansuojama iš ES. Projekto vertė yra 600 000 eurų ir 90% remia Europos komisija, o 10% skiria ES notarų taryba. O kaip žinote, ES notarų tarybos biudžetas susideda iš narių įnašų ir tas biudžetas susidaro iš jūsų įnašų, taigi mes esame už tai labai dėkingi. Įgyvendindami šiuos projektus per pastarosius 10 metų laimėjome, per 6 metus laimėjome 10 tokių projektų ir mes tengiamės platinti savo priemonės, kad notarai galėtų jomis pasinaudoti, kad mes siūlome priemonės ir remiame notarus jiems vykdant savo veiklą su užsienio elementu. L.Net seminaras skirtas 10 šalių - Lietuvai, Graikijai, Vokietijai, Prancūzijai, Italijai, Niderlandams, Portugalijai, Slovenijai, Maltai ir Austrijai. Kiti projektai, tokie kaip Europos notarų tinklas, ir kai kurie iš jūsų tikrai žinote apie tai, juose yra daugybė informacijos apie ES teisę ir užsienio teisę susijusią su notarų veikla dėl šeimos teisės, įmonių teisės, paveldėjimo teisės, pažeidžiamų asmenų, nepilnamečių apsaugos dėl oficialių teisinių reikalavimų dokumentams ir įgaliojimams. Mes kviečiame jūs apsilankyti šioje atnaujintoje interneto svetainėje Notaries of Europe ir pasinaudoti šiomis priemonėmis. Jos yra pateiktos įvairiomis kalbomis. Ir visomis kalbomis yra informacija, visomis ES kalbomis, tame tarpe ir lietuviškai, ir lenkiškai, ir estiškai. L.Net yra 4. ES notarų tarybos mokymo projektas, programa. Mes turėjome ankstesnės 3 programas, irgi su pavadinimu Europo notarams, notarai Europai. Ir padedami komisijos per 8 metus, nuo 13 iki 2020-ųjų, mes apmokėme 5000 notarų iš visų 22 ES valstybių narių. Ir tai sudaro nuo 11 iki 12,5% visų notarų praktikuojančių Europoje. Manome, kad tai yra didžiulis indėlis siekiant ES tikslų, kalbant apie mokymus teisinėje srityje. Ankstesnėse programuose mes surengėme 45 tarp valstybinius seminarus ir juose dalyvavo daug notarų, mokėsi apie šeimos teisę, paveldėjimo teisę ir vienas seminaras, prisimenu, vienas iš tų 9 seminarų, kurie buvo suorganizuoti, jis buvo čia Lietuvoje, tai jo tema buvo kova su pinigų plovimu ir regis prieš keliarius metus šis projektas buvo vykdomas. L.N. projektas, Europos teisė notarams, notarai Europos teisėjai, tai mes ketiname rengti 10 interaktyvių praktinių seminarų, 10 temų, vienas iš jų yra duomenų apsaugos srityje, taip pat šeimos teisės ir įmonių teisės srityje. Anksčiau mes susitelkdavome į asmeninius seminarus, gyvus seminarus, bet dabar, kadangi naujos sąlygos, pandemija ir kadangi notarams galbūt lengviau dalyvauti mokymuose internetu, tai mes nutarėme sukurti mokymosi platformą notarams. Ir todėl mūsų pavadinime yra ETA ženkliukas. Tai yra elektroninio mokymosi platforma, kurią mes ketiname sukurti. Be paminėtų temų, duomenų apsaugos, šeimos teisės ir įmonių teisės, tai mes tikimės, kad su komisijos ir mūsų narių parama mes įtrauksime dar daugiau temų. O dabar mes tik pradedame kurti tą programą Briuselyje, kad visi ES šalių notarai galėtų profesoriai, ekspertai sukūrė metodiką šiems seminarams ir kai kurie iš jų šiandien skaitys pranešimus. Mes mokymosi platformoje turime daug įvairių pavyzdžių, vaizdo medžiagos iš seminarų. Mes taip pat stengiamės užtikrinti, kad visi ES šalių notarai puikiai galėtų taikyti įstatymus. Mes suprantame, kad tai yra nauja teisinio mokymosi strategija ir kiekvienais metais siekiam apmokyti kiekviena šalyje 30% notarų ES teisės aktų srityje, nuo dabar iki 2025 metų. Tikslas yra labai ambicingas, nes iki šiol tik tai 25% notarų galėjo dalyvauti tokiuose mokymuose ES ir nacionalinių lygmenių. Na, o dabar mūsų tikslas yra apmokyti 30% notarų ir tikimės su savo nariais pasiekti šio tikslo. Reikėtų paminėti, kad iš tų 2012 metais buvo kalbama, kad labai svarbu mokymas teisinėje srityje. Ir taigi tokia yra ES komisijos pozicija ir mes tokiu būdu tikimės pasiekti tikslą mokyti 30% notarų. Esame įsitikinę, kad Lietuvos notarų rūmai lengvai pasieks šį tikslą. Norėčiau mūsų organizacijos vardu padėkoti kolegoms, kurie prisidėjo prie šio seminaro rengimo, taip pat visiems, kurie šiandien skaitys pranešimus dėl duomenų apsaugos nuostatų, nes tai yra labai svarbus dalykas mums ir profesinė prasme ir asmeninė. Puiku, kad ES notarų taryba su mumis ir galiu tik pasakyti prezidentui Marijui Straskaičiui, kad mes Briuselyje labai laukiame dirbti su jumis 2024 metais, kai Lietuvos notarų rūmai perims pirmininkavimą ES notarų taryboje. Ačiū jums visiems ir linkiu gerų mokymų.
Dėkoju ES notariatų tarybos generaliniam sekretoriui už sveikinimo žodį ir kviečiu Jūs pažiūrėti trumpą informacinį ES notariatų tarybos parengtą video reportažą duomenų apsaugos tema.
Bendrasis duomenų apsaugos reglamentas įsigaliojo 2018 metais, gegužės 25 dieną. Po jo įsigaliojimo iškilo daug klausimų, kaip užtikrinti padidėjusios notaro ir jo IT tiekėjo atsakomybės įgyvendinimą, kaip įrodyti, kad taikomos
Délégué à la protection des données. Enfin, qu'est-ce que l'obligation de notification en cas de violation de données à caractère personnel?
L'approche du RGPD relative à la mise en conformité aux préceptes en matière de protection des données et à la vérification de cette conformité a fortement évolué. Le notaire doit apporter la preuve du respect des obligations du RGPD, ce qui lui impose de documenter les mesures de protection et de sécurisation des données qu'il met en place au sein de son étude. Il doit notamment élaborer et actualiser du registre des traitements de données à caractère personnel. À cette occasion, il doit se poser les questions nécessaires afin de s'assurer que les mesures qu'il décrit dans sa documentation sont bien implémentées, tant au niveau technique qu'au sein de son organisation. Par la désignation dans DPO, il facilite la mise en place et la révision des mesures identiques.
Notons que les autorités nationales de protection des données peuvent prononcer des amendes administratives pouvant s'élever jusqu'à 20 millions d'euros ou 4% du chiffre d'affaires annuel du responsable de traitement. Ces éléments s'ajoutent à une responsabilité déjà lourde, pénale, qui pèse sur le notaire dans le cadre des traitements qu'il effectue. À ce risque, nous pouvons également ajouter la possibilité d'une action collective.
By the very nature of their profession, notaries are among the largest collectors of personal data. In order to guarantee the legal security of transactions and instruments whose authenticity is ensured, they collect a considerable amount of personal data on a daily basis. Through exercising a form of public authority,
kaip valstybės įpareigoto subjekto pareigas, notarai gauna prieigą prie įvairiausių duomenų, kuriuos griežtai reglamentuoja valstybiniai įstatymai. Be to, siekiant palengvinti administracinę naštą, notarų surinkti duomenys patenka pas administravimo subjektus per saugias IT sistemas, kurios kai kuriuose Europos valstybėse leidžia net tvirtinti dokumentus notariškai nuotoliniu elektroniniu būdu. Elektroniniu būdu registruoti duomenis, saugoti įmonių sandorių dokumentus, pranešti apie tam tikrus sandorius socialinio ir mokesčių administravimo subjektams duomenų rinkimo ir kitais tikslais. Kelerius metus notarams tenka jau laikytis griežtų asmens duomenų apsaugos ir informacijos saugumo reikalavimų. Moraliniu požiūriu, etiniu požiūriu asmens duomenų apsaugos taisyklės sustiprina ir papildo jau esamas taisyklės dėl profesinės paslapties saugojimo ir nukreipimo pažeidimo pavojų. Įvairios profesionalių notarų priimtos priemonės, priimtos valstybių lygiu, tai dalis tarptautinio siekio, kurį skatina ir Europos Sąjunga. Pavyzdžiui, nenuostabu, kad skirtingų notarų profesijų asmenys turi savo etikos kodeksus dėl BDR taikymo. Taip pat nenuostabu, kad kai kurie yra paskirti duomenų apsaugos pareigūnus, kurie dirba šioje srityje, štai Prancūzijoje, pavyzdžiui, daugiau kaip 10 metų. Dabartinis BDR neatskiriama sistemos iš senosios direktyvos dalis. Jis nepakeitė, o tik papildė senesnę direktyvą, sustiprindamas jos principus ir pagrindus. BDR dar geriau užtikrina asmens duomenų privatumo ir apsaugos taisyklių įgyvendinimą, sustiprina Europos Sąjungos piliečių pasitikėjimą jų asmens duomenų tvarkymu.
Taigi visiems dalyviams, dalyvaujantiems seminare, dar priminsiu, kad
Ladies and gentlemen, participants of the seminar, it's a practical and interactive international training seminar. We will invite you to actively both work here and remotely, and you can always send your questions via Zoom chat, because we have also participants who take part via Zoom. The tables here in the room are numbered. Each table has its own microphone. So when solving the tasks, we will invite the teams at each table to summarize your views and answer to the questions you have been asked. Austrian, Belgian, Italian, Lithuanian, Latvian, Polish, Portuguese, French and German notaries are participating today at the seminar. The seminar is being recorded. It's interpreted into Lithuanian and English simultaneously and broadcast via Facebook and YouTube channels. Ladies and gentlemen, participants of the seminar, regardless of the form of participation, you will be issued with a certificate of attendance, while Lithuanian notaries and candidates for notaries or assessors will be awarded qualification points. Let us begin the session of presentations and an introductory speech on the protection of data and its importance for notariate will be presented by Aurélie Merchiol, co-president of the Working Group Data Protection of the Council of Notariates of the European Union. She's a notary from France. Madame Merchiol, if you are here, the floor is now yours.
Good morning. Do you hear me?
Labas rytas, ar girdite mane? I invite all Lithuanian speakers and listeners to take on the headphones so they can listen to interpretation.
Okay, good morning. Thank you for your invitation to intervene in the introduction of this seminar. I have been lending for 10 years the mutualization of the French notary before the GDPR, because the French law established the IT correspondent and freedoms in 2005. I have the chance to chair the DPP networks of the Council of Notaries of the European Union with my Belgian counterpart, Aurélie van der Perre, created in 2017. I would like to point out on this regard that Lithuanian notaries have been present since the creation of this network and have been actively involved in the work of this working group. In introduction, I would speak about the history of the data protection.
Apie duomenų apsaugos istoriją, pasigilinsiu į ją.
One minute, please.
Atsiprašau, minutėlę.
So data protection is a topic that has been really discussed in Europe and in the world since the GDPR, but in fact this issue is older.
Ir šis klausimas yra senesnis negu
in 1948 it appears in the Universal Declaration of Human Rights. So in the Article 12 of that international text provides that everyone has the right to respect for his private and family life, home and correspondence. In 1950 in Europe, the Article 8 of the European Convention of Human Rights provides too that everyone has the right to respect for his private and family life, home and correspondence. At the national level,
privataus
Sweden,
gyvenimo,
Germany, the
korespondencijos
land of essence, followed by
apsauga.
France, were the first countries to
Prancūzija,
legislate on data protection
Vokietija
in
buvo
the
vienos iš
70s.
pirmųjų valstybių dar praeito
In
amžiaus 80-ame dešimtmetyje
1981, Council of
priėmusios
Europe
įstatymus
Convention
dėl
for the
duomenų
Protection
apsaugos.
of Individuals with regard to automatic
1925 m.
processing of
ES
personal data,
direktyvoje
adopted
dėl
in
duomenų apsaugos
28 General
tvarkymo
extends the protection of citizens
buvo
and
išplėsta
their fundamental
piliečių
freedoms,
apsauga,
the right to
o jų
respect for their private
teisė
life.
į
This
privataus
text
gyvenimo
has
apsaugą.
recognized the
Šis tekstas
increase in national
pripažino
and international flows of personal data
didėjančią
through
nacionalinę
automated
ir
processing.
tarptautinę
Today, 55 countries have ratified the convention, including all Council of
apsaugos
Europe
teisę.
member states. This convention has largely inspired the European Commission's 1995 directive on this subject.
Įkvėpė ir
In
ES direktyvą,
1995, the directive on the protection of personal data and the free movement of data was voted, a reference text on the subject. It encouraged most member states to introduce national legislation to protect personal data, where this had not already been done. As its name indicates, the directive aims to harmonize the standards of the various member states as regards the protection of personal data. It laid down three principles: proportionality, transparency, and legitimate purpose, and create a European group, the G29, with the name of the number of this article that created it. This is the anchor of the European Data Protection
duomenų
2018
pagrindinis dokumentas.
2018 entered into force of the GDPR after 4 years of negotiation and more than 4,000 amendments. Never seen as far as MEPS can remember. More than 14 articles of the GDPR leave a judgment to states. Example, the aid of minors. In the same year, Convention 108 was modernized in order to meet the new challenges of new information technologies and to strengthen the arrangements for the effective implementation of the Convention. Lithuania signed Convention 108 as early as the 11th February 2000, 22 years ago. On 4 June 2021, the European Commission adopted the new standard contractual clauses on transfers of personal data to a third country, replacing existing versions. These decisions follows in the invalidation of Privacy Shield and the Schrems II judgments of the Court of Justice of the European Union.
Ir jais remiasi ir ES teisingumo teismas priimdamas savo sprendimus bylose.
What are challenges and what is at stake for data protection regulation? So the GDPR is an evolution, you understand, and not a revolution, I think. The new digital realities have necessitated this regulatory change. Harmonization of rights and duties was also necessary. The transition from a directive to a regulation applying uniformly throughout the EU. Strengthening the rights of individuals, in particular with new rights, or strengthening the legal framework for consent. The issue of data governance is building digital trust through a data-driven and market-driven strategy for competitiveness in Europe and an economic security strategy through cybersecurity. It's also a challenge of compliance with GDPR. there are no longer any pre-declarations
Šiuo
to be
metu
made to supervisory authorities, and a one-stop-shop
priežiūros
mechanism aims to
institucijos
facilitate
yra
the handling of
įsteigtos
complaints
tam,
by
kad
several
būtų
supervisory
informuojamos
authorities.
apie visus pažeidimus.
Accountability,
Ir tai
it's a
labai
dynamic
svarbu
responsibility. You must be able to prove
užtikrinti.
compliance. Record keeping is made mandatory, such as the
Privaloma
register of data processing operations or
registruoti
the
visas
register
operacijas
of
susijusias su
data
duomenų
breaches.
tvarkymu ir registruoti visus duomenų tvarkymo pažeidimus, visus duomenų
At the initiative,
apsaugos pažeidimus.
sorry, it's a mistake. It's there. At the initiative of the state data protection,
Valstybės duomenų
it's not
apsaugos
a good
tarnybos
one. I'm so sorry.
iniciatyva.
Sorry.
Atsiprašau, patvarkysiu truputėlį techniniai nesklandumai.
At the initiative of the State Data Protection Inspectorate, in the end of 2021, the companies Pinter Tyrimai carried out a representative survey of Lithuanians residents focused on the protection of personal data. The survey results revealed that Lithuanian society cares about personal data protection. The inhabitants generally believe that their employers comply with personal data requirements, and more than half of the population feels that companies and institutions ensure due protection of personal data. A large proportion of the poll, namely 70%, are aware of the GDPR as the key leg. As many as 43% of the survey participants are aware of their rights in the area of personal data protection. Respondents with high education and higher incomes, as well as residents of metropolitan areas, are more likely to be aware of their rights in the area. A mere quarter of the poll claim having not known about their right to protection of personal data. 13, a total of 13% of the respondents report having experiencing unlawful or inappropriate processing of their personal data in 2021, while 68% believe they have not faced any breaches. I arrived on the field of application of the GDPR. The scope of the GDPR is particularly broad. From a material point of view, it applies to the processing of personal data, whether automated or not. Therefore, from the moment when a transaction is carried out on the personal data of a natural person, the GDPR applies. Whether this data is digital or in paper format, whether or not it is public. This may involve any operation, the collection, recording, transfer, or deletion of personal data. So reading data is a processing of personal data. This may involve any operation. Data concerned are paper, digital, automated, or non-automated. Exceptions are provided for example, in the context of a purely personal or domestic activity, private directories, correspondence exchanges, social networks, personal websites and blogs, unrelated to a professional or commercial activity. The GDPR not applied to the processing of data concerned by the prevention and detection of criminal offenses.
Certain activities fall outside the scope of UA law, such as activities relating to national security. Processing operations carried out by the member states in the framework of their EU common foreign and security policy. From a territorial point of view, the GDPR applies to the processing of data carried out in the context of the activity of an establishment of the controller or processor in the territory of the Union, irrespective of whether or not the processing takes place in the Union. The criterion of establishment applies. For example, a Lithuanian company providing its services in Europe will be subject to regulation. Following for example, Vinted, following the receipt of a significant number of complaints concerning the online sales site of Vinted.com clauses managed by a Lithuanian company, the data protection authorities in France, Lithuania, and Poland decided to cooperate to monitor the site's compliance with GDPR. The criterion of targeting is added of this criterion. This means that the regulation applies to a manager of or subcontractor who is not established in the territory of the Union, where those activities target a citizen residing in the territory of Union. The criterion applies when offering services to data subjects in the processing of their data. It also applies where the purpose is to monitor the behavior of the data subject. Monitoring of behavior, natural persons are monitored on the internet. Techniques such as profiling of a natural person to make decisions concerning them or to analyze or predict their preferences, behaviors, and mindsets. First, the GDPR will apply to the US search engine or to a Chinese sales platform for offers or targeting citizens residing in the UAE. It is also referred to as residence criterion, as European citizenship is not necessary for the application of the GDPR. In conclusion, the scope of application is therefore very protective in the same way as consumer law. Let us not forget that the aim of the GDPR is to restore citizens' trust and also to foster the free flow of data. Data Governance Acts will soon complement this ambition. I will finish my introduction with explain the sanctions for non-compliance. Two levels of fines are possible. It depends on the seriousity of the breach. 10 million or 2% of company turnover are punished the non-compliance, and 4%, and 20 million of euros for non-compliance with general principles. For example, general principle for transfers, individual rights, transfers, national law, or injunction of supervisory authorities. Class action are possible today to have right to compensation in civil and or administrative courts. For example, class actions against Google or Amazon are faced to several supervisory authorities in France. In France, the CNIL decision of the 7th December 2020 imposed a total fine of 100 millions on Google LLC and Google Ireland Limited. The added value of compliance in relation of the image are very important. Data is as the heart of the concept of trust. Citizens are concerned about the protection of their data. The use of the data makes it possible to provide the high personalization of the advice expected of our clients. Nevertheless, the general public sensitivity to data protection and the need for security are growing strongly. People build up skills. In a more digital environment, data becomes an important element of the customer's relationships, and its volume explodes. The development of new technology, like big data, data visualization, enables companies to develop new services, better manage risk, and improve their operational efficiency. And protecting the image is, of course, very important with data protection. To summarize, why do we comply? The benefit of the four pillars of the GDPR are trust, efficiency, innovation, and security, which are also reflected in the values of the GDPR. Trust is reassuring customers and clients and for patients, members, users, prospecting collaborators by promoting a foundation of fruitful and balanced commercial relations. It is a contract of trust induced by the GDPR. Efficiency, the optimization of their effectiveness, both commercial and organizational, with cost optimization, organization fluidity. Innovation, compliance allows the emergence of new services around the GDPR. And data security means improving the security of the entities' information heritage. So I thank you for listening, and I now yield the floor of the next speaker. Thank you very much.
Dėkoju gerbiamai Aurelijai už jos įvadinį pranešimą. Ir nieko nelaukdami pereiname prie kitos šios mūsų dienos temos – asmens duomenų apsaugos pagrindiniai principai ir veiklos aktualijos, apie kurias mus informuos pranešėja
And now I will give a floor to Madam Morkūnienė. She is Deputy Director of the State Data Protection Inspectorate. Madam Morkūnienė, the floor is yours.
Labą dieną visiems, tikiuosi mane matote ir girdite.
Good morning, everyone. I hope you can see me
Tuojau
well
pat
and hear me
pasidalinsiu
well.
skaidrėmis.
I'm going to share my slides in a minute.
Sakykite, viskas gerai? Tai labą dieną visiems dar kartelį. Tikiuosi mane gerai matote.
Good morning, everyone. I hope you can hear me well and see me well. Today, I would like to thank the Lithuanian Chamber of Notaries for this opportunity to give the presentation. Indeed, we hear a lot in the public space, and we are all people. And today I would like to speak on behalf of the Data Protection Supervisory Authority. What is important for notaries? The interpreter excuses the sound is unacceptable. Indeed, we have talked a lot about different aspects and threats. In general, cooperation is very important. Today, at this event, I see representatives from other countries as well as therefore, I would like to say that the Data Protection Inspectorate is cooperating with the authorities of data protection from other countries. We are exchanging information, we are exchanging the best practice. A lot of things are going on. The person speaking about me talked about the Convention of Data Protection. The data protection standards are really hard, and it is a positive thing because it changes our own point of view without narrowing it down to the rights. The free data movement is important because we live in a global world. It is extremely hard for interpreters to interpret this quality of sound. I do apologize.
Due to poor quality, interpretation is unavailable.
Gerai, supratau. Dabar galiu? Aš labai dar kartą atsiprašau mūsų gerbiamos pranešėjos Danguolės Morkūnienės.
I'm really sorry to say, but due to technical problems, we can't hear you well. Would it be possible for you to disconnect and connect once again? I'll do that.
Kol mes laukiame, kol prie mūsų prisijungs mūsų pranešėja,
While we wait
tai
for
visų dalyvių, kurie fiziškai čia
our
su mumis dabar
lecturer to
dalyvauja,
join us,
maloniai paprašysiu
I would
užpildyti
like to
seminaro
ask
vertinimo
everyone
anketas ir jas
participating
palikti
to fill
išeinant
in
iš
the
salės.
assessment
O
questionnaire
nuotoliniu būdu
of the seminar, and then when
dalyvaujančių
you leave the
dalyvių
seminar, please leave
taip
this
pat
questionnaire
paprašysiu jas
filled in
užpildyti
on the table.
ir
I will
atsiųsti į
also ask
notarų
all
rūmų
remote participants to do that,
elektroninį
and could
paštą
you please
rūmai
email it
@notarai.lt.
to the Chamber of Notaries. Thank you.
Aš dabar puikiai girdžiu, sakykite, ar jūs mane girdite?
Taip, dabar mes
Can you
girdime
hear me
geriau.
well? Now it seems a little bit
Tikiuosi, dar
better.
kartą turėtų būti viskas gerai, tuomet aš dar kartą bandau.
I hope it's going to be better, so I'll share my slides once again.
Ar matote?
Taip, mes jūs puikiai matome.
Yes, we can see the slides
Ar
well.
skaidrės matote?
Do you see my slides now?
Matome jūsų skaidrės.
Yes, we do. Thank you.
Gerai, tuoj. Na štai. Tikiuosi dabar viskas yra gerai.
I hope it's better now.
Taip, dabar tikrai girdėti jūs yra žymiai
Yes,
geriau.
indeed, it seems better.
Ačiū labai. Tai tiesiog nenorėdama iš naujo pradėti,
Thank
tiesiog
you.
noriu pratęsti.
Now I will continue. I will not start over from the beginning.
Neabejotinai, kaip ir visose šalyse, manau, pasitaiko tokių
Without
atvejų,
any doubt,
kai
we
yra
encounter
tam tikrų teisinių normų,
cases
kurios priklauso nuo duomenų valdytojo veiksmų,
when
kaip jisai
legal
įgyvendina
actions
teisės
depend
normas.
on the
Dėl to
data
kyla tam
processor,
tikrų rizikų.
on
Pavyzdžiui,
how these
pažeisti
provisions are
asmens
implemented.
duomenų kiekio
Therefore, there
mažinimo
are
principą.
certain risks to violate the principle of minimization of data. This regulation has changed the attitude towards the data protection. However, before you start processing data, it's you who have to take the decision and not the data protection inspectorate. Speaking of professions like notaries or attorneys, there are many general regulations that have to be applied. However, individual regulations have to be set up as well. Quite often we refer to obstacles, but I regard them as opportunities. The regulation in itself is not an obstacle. It provides us with an opportunity to work transparently and to process the data appropriately. There are a number of purposes for which the data is processed. Sometimes they are defined and sometimes they are not, and there's an extensive freedom to set the purposes of data protection. And you are going to speak a lot today on what has to be managed and ensured in your activities. However, the goals are separate, and accountability is an overarching concept, which is understood in a very broad sense. There are a number of tools that can be applied for its implementation. And there are also certain obligations to provide the information to the Data Protection Inspectorate. You, as data processors, have to have a desire to establish certain procedures for documentation, different standards, and we are going to speak also about the rights of the data subject. And it is a positive development when the information provided to the data subjects are standardized. The scope of data processing may be different. Sometimes there's a question whether the principle of data minimization is not breached. The question is whether the data is not superfluous. Certain data processors may uphold one standard, however, another may aim for higher standards and manage additional risks. This is not bad, however, it is very good to have a certain agreement within the same sector. And data protection is a thing related to values. From time to time, the processes have to be reviewed. Data protection is not a one-time action. When we start applying the process, we have to do it until the end. There's a myth that data protection regulation is applied only to automated data, but this is not the case. This regulation is applied to systemic files, to all the documents. And you, notaries, you have the cases of clients, you have a certain system for these documents, and the regulation is applied in your case in a broader sense. Today, it has been said that the data protection officer has to ensure the appropriate standard for data protection. And I have mentioned that a competent data protection officer is very important to have. Therefore, the data processor has to invest in having these people, allowing them to be trained and to learn on a continuous basis. And this ensures the better quality of pieces of legislation within the organization, on allowing better access to personal data. A competent data protection officer allows managing the risks. In Lithuania, we have 2,746 data protection officers. It's up to you to decide whether the number is high or low, but I think that this is a good beginning. This number is increasing. For example, in 2021, we have 265, about the availability of 265 new data protection officers. Different public and private organizations assess the added value of having a data protection officer, because there is an additional value of having such a specialist. And certainly on condition that this person is really learning and is not only a formality. Having a data protection officer who has no opportunities to learn and who is not included into the data protection processes or planning reforms is not a good thing. The value of data protection officer depends on the company. So it depends on the management of the company, to whom the data protection officer is accountable. We learn from practice that the organizations that dedicate more time and effort to having qualified data protection officers have fewer mistakes, they have fewer problems in communication with data subjects, and they have a stable process ensuring the application of the General Data Protection Regulation. This process is continuous. If 5 years ago certain procedures were good and meeting the standard, they may be outdated today. The data protection officer alone can do nothing. The entire organization has to contribute in providing the information and support from the highest management of the company. What is the role of the Data Protection Inspectorate and Data Protection Officer? I would say that this is a two-way street, because the State Data Protection Inspectorate communicates via data protection officers if companies have them. This way, some time is saved. Otherwise, when a company doesn't have data protection officer, then the company has to learn different things in order to reply to the Data Protection Inspectorate's requests. In certain cases, we still have to prove that data processing includes as operation as simple as making a search. Of course, a lot depends on organizations themselves. I am happy to be able to give a presentation at the event of the Chamber of Notaries of Lithuania, because we have a lot of inquiries from notaries, and these inquiries are of a very high standard. They face us with specific questions, specific insights. Normally, notaries address our inspectorate when they face specific problems, and they already have in mind certain solutions for these problems, which is a very high level of inquiries. This is very important, and probably I don't have to talk about the personal data to such professionals as notaries. Other supervisory authorities face similar problems. Lawyers demand replies of a very high standard. Regarding data processing, I would like to draw your attention to very important aspects. Before processing any data, we have to know about the scope and the purpose. We have to know what we're going to do with the data, and this information on the information on the slide cannot be separated from the data protection principles. The scope of data protection is interrelated with the principle of secrecy. It is very good that you pose questions. Sometimes there are more answers to questions. Well, unfortunately, we cannot see the slides that you are talking about. Could you please... solve this problem. Thank you. I'm very sorry. I'm trying to address the problem. Well, in order not to delay, I will continue. For me, the slides are moving. They are moving on my screen, but I cannot say why they are not moving on your screen. Yes, let's continue. Before starting any data processing, we have to think how things are going to develop. But when we want to change the existing data processing procedures, quite often we think that all the issues have been addressed in the past, but this is not the case. Any change in the data processing can have huge consequences for entire data processing, and it may predetermine the possibility of such data protection being unacceptable. Therefore, we have to check the earlier rules and make sure that nothing has changed. All of these questions can be answered by the data protection officers. I have a lot of experience with data protection officers, and quite often a data protection officer is assigned in one area and then all other employees help. This is the case in the law enforcement authorities. Well, it's hard to say whether this system is good or bad. It is not my duty to assess it. But we see the result, which is positive. Public sector has a possibility to hire one data protection officer for a few organizations. There are many ways and many tools ensuring transparent activities. I would like to draw your attention to topicalities in general in Lithuania. You have probably heard that in the near future we will have public consultations on the law of personal data protection and the regulation of the data protection. Regarding additional regulation, as you know, the EU regulation covers a lot of aspects, such as the limitation of data subject rights and data processing with scientific and historic purposes on archives, and many other questions and opportunities. This regulation has been applied for already 3 years, and I think this is the right time to take a close look whether additional things are needed. We have heard that additional provisions are needed. The technologies are developing rapidly, and new provisions are necessary. We all can participate in these public consultations regarding additional provisions. And of course, we would like to address the notaries and ask them if they have any requests with that regard. The limitation of data subject rights is needed, and from time to time, We hear about this. We understand that not all data subjects' rights can be ensured here and now. There are different factors due to which these rights cannot be implemented, but this should be regulated. Not, we have to indicate not only the legal basis, but also the purpose of limitation. There are different cases. I don't want to say that we lack regulation in Lithuania. It's quite the opposite. We need regulation for achieving higher standards. We have good practice in Lithuania. Quite recently, a law on repeated use of health-related data was adopted. And existing laws may be used for positive purposes. And this is one huge step in Lithuania, that we have come to an agreement regarding the processing of sensitive data. There is a need for additional regulation. I am certain that we will hear about many positive initiatives. The practice of other countries and the practice of supervisory authorities promote better regulation. Quite recently, there was a decision adopted by data protection officer that it was illegal to process data for a long time that were not attributed to any specific categories. Now we have to discuss what data retention period is substantiated, for how long the data can be processed. We need changes in this area as well. When the positive experience has the impetus in other areas as well. New draft laws also have impact on Lithuanian legislation. As you know, there is a regulation on artificial intelligence being discussed. It is also related to data protection. In certain cases, very high standards may not allow certain good products to be supplied to the market. Therefore, our agreement is very important. This is just one of the examples that has impact on legislation, including the national legislation. This is an indication of the direction that we have to go to and the standards that we have to aim to achieve. We do not necessarily have to fine everyone who is breaching the data protection regulation, as this regulation only ensures the change of the culture. It allows a more positive developments. Fine has its effect. However, the aim is for the companies to improve their data processing. 46 of the respondents asked said that companies, they wanted companies to be punished, not only improve their practices. People do not aim for the satisfaction for companies to be fined. It is more important for companies to improve their practices. the penal responsibility is not foreseen for all data breaches. Regarding the situation in Lithuania, we see that in terms of sanctions, they are growing in number. However, certain problems are being addressed when using other means such as reprimands or instructions to improve the procedures. In certain cases, we lack resources. The trust is increasing in Lithuania because the number of notices on the breaches of data processing has increased, and it is growing in number each year. In Lithuania, about 3 million people were affected by data breaches. The cyber incidents are on the rise, and they become more complex. There's lower number of data breaches due to human error, which is a positive development, because we dedicate more time on training, on data protection, on providing the information. The trends are quite positive. However, there's one negative aspect. In 2021, we received 9 notifications about the cases when the information from the databases was leaked. And this is not good, because the personal data of 1 million people have been leaked. And that's why the data protection regulation aims for high standard, because the consequences of data breach can sometimes be felt a year or 2 or 5 years later, not necessarily immediately. There are different types of incidents related to data breaches. Why is it so important to raise awareness about the standards and not to be afraid to say that we are in line with the General Data Protection Regulation? During this situation of pandemics, people have noticed, for example, 40% of people thought that it hasn't changed. 24% of people said that the requirements were not observed more. Despite the fact, the knowledge about the data protection regulation reaches 74%, and I think this number is really positive. People have their opinion about the implementation of requirements. It has been quite hard to adjust in the past 2 years, because we have been working distantly, learning distantly. The employers were collecting certain personal data, and the data protection requirements had to be implemented today and now. Therefore, we face challenges, but I hope that we will manage to meet them somehow. The Data Protection Inspectorate is not attempting to fine everybody. We apply sanctions only in exceptional cases after assessing all the circumstances. In 2021, we have calculated the level of data protection, which was 60%, and it consisted of 4 indicators reflecting the information about data protection, trust, the assessment of infringement, of breaches, and supervision. The program has been in Lithuania, the national program has been adopted until 2030. And we are going to monitor this level in Lithuania, and we hope for its improvement by 10% each year. In certain cases, we see that companies avoid providing specific information, and sometimes we suspect the breaches to be intentional. And in these cases, our inspectorate is forced to imply sanctions for lack of cooperation. Sometimes we see abuse from data subjects because they complain to our inspectorate without talking to data protection officer beforehand. We know about, so to speak, professional data subjects who know the regulation well and who attempt to manipulate the organizations. The most important thing that I want to say is that when a data subject files a complaint, and if you are not working on it, then you have to provide the reasoning for not doing that. Even if the request is not proportionate, you have to indicate why you refuse to process it. Well, I didn't mean to say that everything is bad in Lithuania, but sometimes a few negative examples are followed by others. In the context of data protection, notariate is not the risky sector that is abusing or lacks competences to address data protection issues. We all have questions. And finally, I would like to draw your attention to the mobile application, which is called ADA Gidas, where you are able to inform about the problems, about best practices. We receive some positive notices, and probably some of them are going to be the precondition for inspections. Sometimes when we receive one notice, we have one way to proceed, but when we receive a number of notices on the same issue, we have a different way of proceeding. The learning of data protection officers is very important. And finally, I would like to welcome you all, and I'm happy to say that you can contribute directly to the data protection. I have looked at the exercises and the tasks that you are going to address today, which are very important. And indeed, sometimes data protection involves other things than high technologists. Sometimes it is enough to lock the door or to lock the screen, the computer screen, and have in mind the simple measures such as passwords. These simple things ensure positive results. So I hope that you will not look at data protection as a monster. We do have a number of rules, but please view it as a possibility, as an opportunity for developing your activities. Well, I hope that the technical problems were not still allowed you to hear me.
We thank the speaker, Madam Morkūnienė. Under the timetable, we still have 5 minutes before the coffee break. For our seminar to be useful not only to notarians, but also in practical terms, let us cover the first practical case. You have practical cases on your handouts. Also, I hope that our remote viewers also have the handouts. I will read out the first practical case and I will cover the possible answers for the case. So, the first case. In the course of electronic correspondence between a notary and a client concerning the coordination of the details of the transaction for the transfer of real estate, a third party has seized control over the email account of the notary or that of the client and modified the content of the client's email by changing the name of the bank and the account number. As you can see, 2 breaches have been made. Seizure of control over email account of a notary of the client, and modification of the content of the client's email by changing the name of the bank and account number in order to absorb financial means. What should the notary do after having noticed that the content of the email has been changed by the third party? Let us begin with a coverage of answers. What should a notary do? First, inform the client about this telephone and this by telephone and ask for accurate bank and account details of the client. The notary should immediately log out of all active email sessions and reset his user's password in the email. And the notary should document the personal data breach in the data breach log. This is the procedure of that the notary should take. In the first case, where it is said that the notary should inform the client about this by telephone and ask for accurate banking and account details of the client, these are actions that a notary should not take because he could not deny that there was a data breach and he could not fail to react to it. A second answer, inform the client and the competent supervisory authority. You might think this is the right answer, but we can see that actions like this by notary are not sufficient in this case, and the notary should take additional protection measures to protect and secure his own computer and that and the email box. I can see that it is now high time we had a coffee break. So please go to the coffee break and see you again in half an hour.
Tęsėme mūsų seminarą tema duomenų apsauga.
We continue our seminar on data protection, and we will now hear on data protection and cybercrime from Dr. Anatoly Nechiporenko, Information Systems Administrator of Lithuanian Chamber of Notaries. Anatoly Nechiporenko, the floor is yours. Good morning, ladies and gentlemen. Today, I'll make a presentation in Lithuanian, and it might differ from the presentations you previously heard from our speakers on legal matters. On the declarative part of the BIDAR, my presentation will differ. It will be on the imperative, on the implementation and the threats. I will cover the ways to protect yourselves from the threats, and to prevent yourself from becoming a victim of data theft. I have three subtopics. First, I will talk about the fundamentals and the guiding principles of data protection. Next, I will talk about cybercrime. And last but not least, I will talk about remote notarial actions and the threats that belie them. First and foremost, let me tell you that we personally store some kind of data. This refers to archiving and storage of data for a long time. Data must be archived under our laws, and they contain personal data. We also have data that is not archived. Data you may well know about, such as mail correspondence, draft contracts, scanned versions of clients' documents, personal data and documents sent to you by clients, scanned documents. And you have those documents on your system very often in your offices, in your workplace computers, in your email box. Please don't forget that this data also has its own storage policy or data retention policy and a life cycle. A life cycle of data starts when you get the data, continues when you work with the data, and when the data is no longer necessary. You may all know that you receive an claim from the client. You need to search for or ask for certain client's documents on ownership. You may need documents from other parties of the transaction, and you have, as a result, a number of documents on the basis of which you create a document. Where do you later put all the data? Maybe they still remain on your workplace computers. Unfortunately, they also contain personal data. The Lithuanian Chamber of Notaries has provided certain recommendations and general guidelines on protection of personal data and on the principles for treatment of personal data. Article 6 says that based on BIDAR, on GDPR, the principle of data retention limitation, data may only be retained in as long as the need for their processing is in place, and not longer than that. How do we implement that provision? We had contacts with notaries on that matter. I was interested in the ways they receive emails, the timeline when they how they retain draft contracts, and how they erase them. I heard that after the notarial action is completed, the notaries do their best to delete the data, but not always as soon as we would want them to. The reason why some of the data is not erased immediately without the possibility to revive them, one of the reasons is possible legal consequences, such as disputes with a client. A client might have asked for one thing and received something quite the other, and client's wishes might have been not implemented in the contract, and correspondence may be used to prove that who was right, who was wrong. But to my opinion, this is not to be allowed. It is illegal, unlawful, and data can only be retained insofar as there is a need for the treatment or processing of the data. Our email service for the Lithuanian Notariate has migrated recently, and we noticed that a number of notaries have the long time archive of correspondence with clients where correspondence dates back to a year still remains in place on their computers. This demonstrates that they can treat the data and can learn from the data, but this also creates a risk that this data may be stolen, and should they be stolen, there would be a lot of data. That would be a lot of data, and that would be more data than would be the case in the case where you process the data and delete them faster than you normally do. How do you store? How should data be stored in a notary's work? You clearly understand that you have a workplace computer. This is we talk about your workplace computers, computers of your staff. All the data and all the contracts are drafted in your notarial office. You have also an email. You may think an email is an email, but please note that an email is a very important thing, because through emails your data may leak. Your email is a portal to the so-called private area of private data. Notary is responsible for protecting that data. You also have IT systems. IT systems that are used for the work of notaries. In Lithuania, we have a system called e-Notaras, or e-Notary, electronic notary. We store personal data and data of all contracts there. The data on e-Notary system is processed under Lithuanian laws. Some notaries may not think that personal data are also stored on their representative websites. If you are a notary, if you have your website where you allow customers to register for meetings with you, for appointments, for a certain time, your clients will leave not only their name, their surname, their telephone, and maybe even their email. And this is personal data. You have to be serious about this. If your website retains this data, you have to erase the data on a timely, in a timely manner. After the notarial action is completed, you have to delete the data, erase the data. I'm a person who works with technical things rather than law. Our main aspects on data security and on cyber security contain 3 building blocks. They are called in English the CIA. This stands for confidentiality, integrity, and availability. System security and impacts are assessed based on CIA, on confidentiality, integrity, and availability principles. Confidentiality, integrity, and availability. As far as confidentiality is concerned, this is your ability to provide protection of data. How do you do that? Encrypt them. You can also lock them in an internal system to which access is only available through your notary's office. And it also contains all measures that ensure the protection of your data. What is integrity? This aspect ensures that data is not changed. The data you have and the data that must be present in a contract have to be there. They may not be changed by third parties. No third party may enter the data and change them or abuse them. How can it be abused? Let's say they may be erased or encrypted. This would mean abuse of integrity of your data. So this aspect is very important. Finally, availability of data is the third principle. If you have any data, but you cannot access them, the data is of no use. Let's say you have data on your work server, but the server has broken down or became inaccessible. You cannot access your data. As a result, you cannot work in line with your functions. Well, the data will not be stolen, but you cannot access it either. Please note continuity of work is very important. All these 3 aspects, confidentiality, integrity, and availability, contribute to business continuity. And notaries, as data subjects, must ensure the continuity of their activities. You must have or may have a business continuity plan. And I recommend you to have a business continuity plan and a disaster recovery plan. Please do note what kind of data is stored on all computers of your office, and or at least part of your computers, as well as backup copies are stored on your computers. The storage of backup copies must ensure the integrity, confidentiality, and availability of data. Therefore, it is necessary to encrypt the data before storage. Cryptography functions allow you to check the integrity of the copies of the data. Availability is ensured by storing backup copies in an office backup location. So you may want to send your data to an off-site backup location. In completion of this part of my presentation, one of the main principles is that after the storage or retention period ends, when this personal data is no longer necessary for the purposes it was used, is the documents and their copies based on the rules for processing, transfer, and retention of documents shall be destroyed unless the data are archived in line with the Lithuanian laws. The documents and their copies must be destroyed, so none of them or parts of them can be recreated or restored. Let us now move to cybercrime. One of the most important and crucial aspects for stealing data and for data breaches and breaches of rights of certain individuals or persons, one of the greatest and most serious threats are ransomware attacks and encrypting attacks. This is a very widespread sort of attack, form of attack. The attack is organized in order to get some ransom or some money in exchange. In English, it's called ransomware. You can look up on Google about ransomware. DDoS attacks, or distributed denial of service attacks, are not so important for notaries. They are more important for IT staff, because thanks to them, information systems operation can be stopped and will not be available for some time. Phishing is another form of attack. Let us say you receive a link and an email with a link. In the email, you will be asked to do certain action. I will talk about that later. And social engineering is also a malign activity where persons call you and they represent themselves as other persons. They try to get some information from you, some data from you, or they try to make somebody do some action, and the impact of that action will be useful for the person, for the author of the attack. Electronic payment, cryptocurrency-related actions on the internet are also quite dangerous. Let me now give you several examples of what happens in your may happen in your daily life. It happens in my daily life. It happens in daily lives of my colleagues. Let's say you you are a user of an email box. You receive an IMG format attachment, and your email message will say, please open the attachment because it contains important data. In the case of a notary, the email may say that it contains in the attachment a scanned passport or a scanned contract, and the message and the email will say, this attachment contains my information, please open it. After you open the attachment, another zip archive will open up, and there will be another file inside. It will say, open this file. Or maybe sometimes you will open the document and you will see a document, but at the same time there will be a malign attack on your computer. The entire computer and the entire internal network, wherever the program will find data, it may start encrypting the data. It takes a lot of time, not just 1 second or 2 seconds, because all the files, all the data is encrypted. As a result, you receive a notification on your screen or a letter that all of your data is encrypted, and you will ask for a ransom. You will be told what kind of sum you need to pay in order to reach the data that is encrypted by the malign software. How do you work against this? First of all, you need to have backup copies. Backup copies are vastly important. Sometimes you may think it's too expensive. Sometimes you think it's complicated, but you do need the support of IT staff, and they can provide you with software which will do that on an automatic basis. Making backup copies is vastly important. Once it's automated, it will not ask or invite any additional action from you. When backup copies are made immediately or on a timely basis, you may only lose the results of your work of 1 day or 2 days, but not more of the results of your day. And you can always restore the data, because contracts are always signed by hand, also, and you can always restore data, or at least you will not lose the data accounting for your entire career or for entire year. What about DDoS, distributed denial of service attacks? Malign actors may want to order a distributed denial of service attack targeted against you. It's an attack against an IT system where too many functions are enacted so that the system is at a loss of which order to implement and stops working. To notaries, this happens seldom. The notarial system of Lithuania has not faced such high attacks so far, but your notarial office IT address may be attacked by DDoS, and you may lose an internet connection for some time. Of course, we do have our mobile phones with us always, and we can always turn on the access point and use our internet connection via mobile phone. The DDoS attacks usually last for some time because they are quite resource intense, so sometimes they may last up to a year. Now, data security breaches and phishing. Phishing is a widespread form of attack. The user is often receiving an email, and for instance, it says that you are addressed by, let's say, a DHL or a DPD or the Lithuanian Post, Lietuvos paštas, and the email asks you to contribute with information because they ask for your name, surname, email, telephone number, and this way you can open your personal data, which may not be nice sometimes, and provide somebody with some malign actor with that data. Another type of phishing is a case where you receive an email which says that your email is full, there's no more storage space, and you asked to enter a link and to connect to that link. By doing that, you can now demonstrate your user account, and this will open the door for data theft. All email addresses may be sent from your computer, and they also may be destroyed, all of them. So you have to be very serious about this. My presentation also contains some recommendations, but I will give them to you at the end of my presentation. Remote authentication of notarial actions is in place in Lithuania since last year. A number of notarial actions have already been completed. We have pooled our efforts so that now we can do notarial actions even while we're at home or on vacation. But there are some threats, especially for notaries, because notaries are the party which completes an action in cooperation with a remote person. And it's sometimes quite misleading because the identity of that person may be changed. Let's take the example of remote meetings. A remote meeting is a format in which a notary interacts live with a client. What are the threats there? Well, first of all, you must only use the software provided by your software provider. In Lithuania, we use Microsoft Teams for video conferencing and for contacting our clients. And we use Docobit platform for signing electronic documents. It might happen in your life where your clients will tell you, I cannot access your link, it's impossible, can we please use another format of video conferencing, such as WhatsApp, FaceTime, or any other tool that is freely available to all. Please note that you must stop this immediately. You should not agree to this proposal from your client. You must stop your notarial action immediately and never join the other video conferencing platform. Your client may also say that he cannot sign the document via Docobit. He may say, well, there's another platform, please connect to it and authenticate the action. Please don't do this, because you never know what what your email e-signature may be used for in the future. You may sign a document, but this may only be a cover for selling your own real estate to a third party in a third country. It's a very dangerous action. So never connect to the platforms offered by your clients insofar as authentication is concerned. All links are generated, in our case, only via the e-notary system. And these are the safe systems. These are the safe links. Other links are not safe. Another important risk related to remote notary actions, which has not been seen in Lithuania so far, but technologically possible, is the threat of deepfake. where in real time a human face is replaced by another person's face. You may think it's impossible, but if you look up deep fake in YouTube, you will see famous actors and their faces on video screens where they never were, in fact. And you will see scenes from films with one actor replaced by a face of another actor. In our notaries' work, we think we will never see that. Unfortunately, I think the technology allows this, and we may see similar attacks. So how do we protect ourselves? In real time, during video conferencing, so far the technology doesn't allow humans to be moving fast, where faces move fast, where the head is tilted, or turned to the right, or turned to the right, or to the left. It's quite hard for the technology to imitate that. These parameters are quite hard for algorithms to tackle. So if you have any problem seeing the client's face, or if you have any doubt about the client's face on the screen, if you think that the client's face is falsified, please ask your client to turn his head to the right or left, up or down. And if you see that the face seems to change the quality of vision or changes the color, please ask your client to come to your notary's office physically. This way, you will protect the person on whose behalf an attacker might be acting. In order to prevent deepfake technologies, you can also use biometrics. There are algorithms that can compare a person's face to a photo present in the residence register, in the population register. So the photo in your ID may be compared against a photo in the on the screen. This will help to calculate whether the person in front of the screen is similar to the person whose identity he uses and whose photo is in the population register. In Lithuania, we are now launching this tool, and will soon be able to offer you biometric verification tool. The biometric verification tool also allows to conduct the so-called liveness detection. This means that you will be sure that you have a person in front of you, in front of the screen, and not just a photo of somebody. You will be sure that the person is sitting live against the camera and not just putting his photo, which acts as if it's a real person. This biometrics tool will also allow to establish whether it's not a deep fake also. So we will have all tools in place to safeguard our notaries from these types of attacks. As for our recommendations, what are the best ways to deal with the threats I've covered? You may think you are being scared. Well, please don't be scared. Simply be informed about the threats. Our recommendations to protect the personal data include annual reviews of ports of your work computers and servers or mobile devices, the scanning of these ports and audit of software is crucially important. This is necessary in order to prevent the creation of conditions for malign software, opening the door to personal data theft. Computers and the network have to be protected against violations and you must update your router, your computer, all your mobile devices on a regular basis as required by the producer. Software needs permanent updating. You cannot just buy a computer and never update it in 10 years' time. No. And only certified or qualified experts must update your software. It's equally important to ensure monitoring. You need to monitor the devices of your network. Of course, it costs you additional money, but through monitoring, you can also notice the signs of attacks. You can notice data theft, and you can always learn when data theft took place, because IT means we have a time frame. We have an IT and time frame with the past, the present, and the future, and all things that happened in the past may not be changed. If data was stolen in the past, you will never restore them. But if you learn about the fact of data theft, you can prevent the data theft in future. Because data theft doesn't just happen within one day. No, it's usually happening within a longer period of time. A thief will ask you for a ransom, maybe when you need some sensitive data, and the thief can also sell data to other subjects. So that's important to know. As to data, personal data, you need to use unique passwords to access personal data. If you have in your notary office 3, 4, or more computers, and you have a server, or if one of the computers serves as a server, you must protect them by passwords. The shared folders must be protected with passwords. Access to personal data must be available only to those persons or staff who work, who make certain actions with that data at a certain period of time. And let's say in your office you have one employee working with natural persons and other employees working with legal persons. Don't put all your files into one place. Some employees must only have their access to some files and others to other files. The principle of the least privileges should govern these actions. You must ensure the protection of software from malign activities such as viruses. You must have antivirus tools, or at least Defender if you have Microsoft tools. It's also crucial to make backup copies, to decipher, verify, and back up your copies at least in 3 places physically. That's very important. If you have any questions on the implementation of these steps, you can always address me. We will always provide you with recommendations. We will find staff who can make an audit of your network and help you on all those aspects that I have covered today. Thank you. And I have one small question to you. As today is a day when we work in questions and answers form, I have a question on the second page of your handout. It's the very last practical case. A notary's client has learned that the contract concluded by the client and certified by the notary became available to third parties. An electronic document there is a chance that the contract could have been fraudulently seized, stolen, or copied from the notary office. What steps should the notary take if there is suspicion that the contract in question has been fraudulently seized in the notary's office? You have 6 answers, possible answers. So you have a multiple choice question. One of the answers is check the notary's own computer and those of staff of the notary's office for a possible virus attack. Second, change the password of the Wi-Fi network of the notary's office. 3, check if all the data sharing folders or databases are password protected. 4, if the contract was sent by email, change the password of the email and inform the entity in charge of administration of the notary's mailbox. 5, notify the competent supervisory authority of the incident. And 6, recommend that the client takes care of the protection of their own data. You may clearly see that most of the answers are right, apart from the last one, recommend that the client takes care of the protection of his or her own data. It's laughable because maybe the data can be leaked from the client. So let me tell you without further ado that you should truly check your own computer and those of the staff of your office for a possible virus attack, because data is often stolen through virus attacks. You have a virus in your computer, and then the virus may send or leak your data, or encrypt your data, and so on. Why should you change the password of the Wi-Fi network of the notary's office? Well, if you give that password to third persons, they could have joined the Wi-Fi network and get this data through the Wi-Fi network. If you, unless your databases and backup files were password protected, that's why you need to check if all the data sharing folders and databases are password protected. As for the email, if third parties had access to your email, then they could have stolen your contract. So you must inform the entity in charge of administration of the notary's mailbox, and you must change the email password. You must also notify the competent supervisory authority of the incident, because this is data theft. And unless you make actions, you will be breaching law. Thank you very much. I hope you were interested in what I said.
Thank you, Mr. Nechiporenko, very much for such an interesting presentation. Now I would like to give the floor to another presenter, that is Thomas Kot, and he's Vice President of Polish National Notaries Council and a notary. Thomas, the floor is yours.
Thank you. Ladies and gentlemen, dear colleagues, firstly, I would like to congratulate to our Lithuanian hosts for today's conference. Spring meetings in Vilnius are already becoming our notarial tradition, and the tradition is a value very important for the notaries. Unfortunately, the condition of the pandemic mean that not all Polish notaries can participate in person in this conference. So I please to excuse us for it, and just only one for representing our community. Couple words about the personal data in Poland, protection of personal data in Poland. Each of us agrees that his personal data should be protected. No one, without our consent, should be able to collect, process, share it with others, or draw conclusions about us on this basis. But the problem arises when we are the entity collecting, processing, or sharing such data with other people. Especially with this action are not at heart our day-to-day activity. After all, our primary task as a notary is to perform notarial actions and not to process personal data. That is, no one pays us for data processing. This problem became significant on 25th of May 2018, when the provisions of regulation of the European Parliament and the Council on the protection of individuals with regard to the processing of personal data and free movement of such data are entered into force. When referring to the regulation in my speech, I will use GDPR acronym. The new provisions of the GDPR have violently interfered with the sphere of our habits or previous practice. If our actions include the processing of personal data of other people, that we must take into account the new regulation. This entry in force of GDPR was followed by the usual wave of hysterical reaction to the new regulation, and some effects of it become absurd. Entry into force new regulation and new obligation was treated as unnecessary obstacle at our day-to-day work. We can say what Mr. Jourdain of Molière discovered, that he was speaking prose. So the notaries discovered that they processing data. But protection the personal data is nothing new for us. And we notaries have always used the protections mechanism in respect of personal data collected when performing our duties. The instrument when we used for this purpose was common to all of us. It was the notarial professional secrecy. We knew how to keep professional secrets without any new legal regulation. One has to admit that the entry into force of new legislation coincided with the widespread use of new technologies and new tools in our daily practice, such as office software, word processors, internet tools, electronic mail. At the same time, Polish notaries also collect additional data that requires processing and reporting to state authorities, for example, in the field of money laundering. Many of these phenomena have been regulated separately, but many of them not, because they are part of natural technological changes, and we use them in connection with the industrial and social advancement. In the course of discussion on the application of GDPR by Polish notaries, the National Council of Notaries adopted on 4th June 2018 a position on the application of the GDPR provisions in the context of notaries' obligation to maintain professional secrecy. This position aptly points out that in the light of the existing regulation, the obligation of a notary in the field of personal data protection of natural person should be considered from two perspectives. That is, from the perspective of notary as an entrepreneur, and from the perspective of a notary as a person practicing the professional of public trust, which is related to the processing of data of his client. In the first case, when processing personal data, the notary applies the GDPR as an entrepreneur. In the second case, the notary's obligation is the broadly understood scope of personal data protection are determined by the principle of secrecy. The obligation results from Article 18 of the Polish Notarial Law Act. A notary is obliged to keep secret the circumstances of the case which he learned about during the course of the performance of his notarial duties, and has priority in application over the provisions resulting from the GDPR. To sum up, the professional secrecy duty owed by a notary and the specific nature of his protection enable us to take the following position. Article 15, Section 1 and 3, as well Article 19 and Article 21 of the GDPR do not apply to a notary in the scope of activities performed by him under Polish Notary Law Act, as well as in the scope of other preparatory activities undertaken by him in this regard. Such an exclusion was provided for in the draft Act on amending certain Act of law in the part concerning the Notarial Law Act. Article 23 of the GDPR restricts its application inter alia in the law of the member state which the data controller is subject restricts to scope of the obligation and rights provided for Article 12 to 22 and Article 34 as well in Article 5, provided the provisions of the law of the member state correspond to the rights and obligation provided for in Article 12 and 22 GDPR. In connection with the entry into force of the GDPR, the Polish legislator changed the provisions of the existing Act in this regard and introduced a number of new so-called sectoral regulations. The Act of 21 February 2019 amending certain acts to ensure the application of GDPR regulation. According to this new law, added Chapter 8 on personal data processing in Notaries Law Act. The following provisions were introduced. Firstly, Article 78b. The provisions of Article 15, Section 1 and 3, Article 18 and Article 19 of GDPR regulation are applied insofar as they do not constitute a breach by a notary of his obligation to maintain secrecy referred to Article 18 Polish Notarial Act. The provision of Article 21, Section 1 GDPR regulation is not applied for personal data obtained by a notary when performing notarial actions. And the secrecy obligation referred to in Article 18 Polish Notary Law Act does not cease if the President of the Personal Data Protection Office has requested the data obtained when performing notarial action be revealed. And on the end, the period of storing personal data collected by the Polish Notarial Council of Notaries, Councils of Notarial Chambers, and the Examination Committee when performing their duties under the law is for 10 years following the year in which the procedure for which data was collected has been completed. the provision of Articles 90, paragraph 1 applies best by analogy. Today's situation about the protection of personal data in Polish notary is we don't have a code of conduct mentioned in Article 40 GDPR. So any notaries should prepare, we can say, internal bylaws regarding the processing and protection of personal data, including a response to take leakage of such data. In practice, notaries, in order to protect the right of person participating in notarial activities, provide them with information on the processing of personal data, whether in the form of a written notice provided to clients or by displaying them in the office or even by including such information in the notarial instrument drafted as a result of a notarial action performed by the notary. Notaries have in place appropriate safeguards against unauthorized access to the database kept by notaries. Notaries encrypt the email correspondence, in particular the draft of notarial instruments which are sent to their clients. Similar measures are undertaken by the bodies of notarial professional organization. We don't have many information about the breach of security personal data in the notary's office. It's not a problem in Poland. The notaries take good measures to protect this data. And situation in Poland in this matter is not so bad. We can say it's quite good. We are on the medium in Europe about the number of unauthorized access to personal data in general, according to European information from the European authorities. But we should always think about the protection of personal data, because today, in changing world, in changing technologies, it could be dangerous, and it could also involve many costs for the notaries. And it's all. If you have the question to me, I can give you a response. And if you allow me, say 4 words in Lithuanian. Labai ačiū už dėmesį.
Thank you for your attention. Thank you.
Tai dėkojame gerbiamam pranešėjui už iš tiesų labai įdomų asmens duomenų aptarimą Lenkijoje. Ir dabar pagal mūsų programą mes turime pertrauką, ir mes jūs visus pakviesime sugrįžti į seminaro salę 14 valandą. Dėkoju Jums už dalyvavimą pirmoje dalyje.
And see you soon.
Taigi, sugrįžę tęsėme seminarą
Ladies and
duomenų
gentlemen, shall we
apsaugos tema.
continue with data
Visų čia
protection?
dalyvaujančių salėje
I
paprašysiu
would ask
naudoti
everyone in the
ausines
hall to
tam, kad
use
gerai
headphones so that
girdėtumėt
you
visus
can
pranešėjus.
be better
Taip
placed
pat
to hear the
priminsiu
speakers.
užpildyti
Please also note
seminaro
that you are
vertinimo
required
anketas ir
to fill in
palikti
the
salėje, o dalyvaujančių
questionnaires on the
nuotoliniu būdu
seminar and leave them in
paprašysiu
the hall.
atsiųsti
And I
anketas
will
į
ask those who are taking part
notarų rūmų
remotely
elektroniniu
to
paštu
send the filled-in
rūmai@notarai.lt.
questionnaires to the room at
Taigi,
notarai.lt, to the email of the Notary
pagal
Chamber,
programą
so that we can
apie duomenų
assess
subjektų
the
teisės
data.
mums pranešimą skaitys
Under
Miglė
our
Petkevičienė.
agenda now we will hear
Lietuvos
from
duomenų
Miglė
apsaugos
Petkevičienė, member of the
pareigūnų
board of Lithuanian
asociacijos
Association of
valdybos
Data
narė,
Protection Officers,
Alex
partner at
advokatų
Alex Law
kontoros
Firm, and
advokatė.
she will speak about the right
Dėkojame
of the person
gerbiamai
concerned,
Miglei,
of the
kad ji
data subjects.
sutiko pasidalinti savo
Rights of the data
žiniomis ir
subjects.
kviečiame ją
We thank
pasisakyti,
Miglė Petkevičienė
jeigu
for
ji yra
being
jau
ready to
prisijungusi
share
prie mūsų.
her experience. We invite her to join. Can you hear me? Hello, can you hear me?
Negirdžiu, kad kas nors sakytų, bet jeigu negirdėsit,
If you don't hear me well,
puiku,
please let me
sakėt,
know. Okay, I can see you can
sveiki,
hear me.
laba diena,
Welcome.
and
Good
now
morning.
I will switch to English, because I was asked to switch myself to English. And now I hear the voice of the translator, so I don't know how to do that, but hopefully our technical staff will somehow silence that for me. And I will start sharing the screen. I hope you can see it. Okay. And I saw that some of the speakers have had some issues with their internet, their technical problems. So I hope the internet gods will take it from that and everything will be great. So I will start my presentation. I know that you have just recently came back from your
Miglė,
lunch
aš
break.
labai atsiprašau jūsų.
Just to make sure that
Jūs mane girdite?
I get back the attention. And
Miglė, can we ask you for attention?
I will try to start with a bit of funny quotes and funny examples. So that you all are on the same page with me and that you are present here and I get your attention. So thank you very much for inviting me to this event. I'm really happy to be here with you. So as I was introduced, I'm a board member of the Data Protection
Labai
Officers
atsiprašau
Association of
jūsų.
Lithuania, and I'm
Gerbiama
also a
Miglė,
partner
ar
at
jūs
law
mane
firm
girdite?
Alex.
Turiu jums vieną
So
prašymą.
there's this urban myth about the dragon named General Data Protection Regulation. So the legend says that it is highly complex, it's very scary, it's over 90 pages long, it's 99 articles plus extra almost 200 recitals. It never sleeps, it is applied to all situations and all circumstances, and the companies and all the institutions and all the data controllers, including notaries, shall stop whatever they do and start doing only data protection related work. And whoever asks to provide information about them, you have to put your hands up, give everything you have, and offer a candy on top or something. And that the authorities are coming with their swords to collect the fines. And oh, the fines, they're really huge. And everybody shall run and hide from those fines right now. So stop making notes. Of course, I'm really exaggerating. Data protection is not about that. These are just a few misconceptions, or as I say, myths related to GDPR. But it's not really what defines data protection and data processing. So is it really complex? Yes, it is really complex, but it doesn't mean that it is too hard to understand or apply. Is it really applicable in all situations and circumstances with no exceptions? Yes, it's really, really applicable in all situations, but it has to be applied. It's not really the highest law. It has to be applied in parallel together with all other applicable laws. Is it an absolute priority? Sure, it is really important. And I will talk about it in a moment. It was already discussed today, but I will also try to address this in my presentation. So are the rights granted to data subjects according to GDPR absolute? Well, no, they're not. There are some exceptions, there are some exemptions, and many other aspects have to be taken into account while granting. We'll talk about it in a moment. And fines, yes, sure, they are really high. They're really worrying, scary. They're up to 4% of company's annual turnover, or 20 million. But they're there with a aim to deter from the data breaches and to make companies or data controllers, including notaries, respect data and its privacy. So it's really not what defines the GDPR. GDPR is actually about the balance. I am here to talk to you about data subject rights. So you, the most respectful notaries of all people, are really the ones to know that the balance is the key. Where there are rights, there are also obligations. And the fact that a person claims that he has a certain right does not make you free of any legal obligations you may have according to the law. Anytime certain person claims that he has a certain right according to GDPR, please remember not the dragon a few slides before, but this picture. Calm your mind, any noise that may be around. Remember the sea, the stones, maybe the noise and sound of the music of the waves. And try to think that actually there is a balance, and remember this perfect balance when you speak about the data protection rights. So let's talk about this balance in your work, especially in these daily situations where you may be asked to grant certain rights as a client, to interested party or some other person, and how to find this balance and where does it lay in data protection. This is what we are actually going to talk about today. I will try to somehow mute the interpretation sound because it's really making me distracted, but I don't know how to do that. So, yeah, if somebody from the technical team could help me with that, how to switch this, that I don't hear that. But yeah, so actually, as I mentioned, and as it was mentioned also in the Data Protection Authority's presentation, is that GDPR is actually all about respecting data privacy rights. So when we have any kind of data subject request, we definitely have to protect the personal data. All the data subjects have the right to the protection of personal data. But actually, it's also about the right balance with the other rights. So it's not an absolute right. It has to be balanced against other fundamental rights. It's also said in the GDPR, it's said in the recital 3 of the GDPR. So maybe this dragon, this urban myth that I have been telling from the beginning isn't what it really seems. And my today aim is to show you that this dragon may be friendly, sometimes even funny and nice, but it is never a bad guy. We have to help him do his job. So let's go to the discussion of rights of data subjects, and we'll go one by one to these data subject rights that are there in the GDPR. So the following rights may be granted to data subjects according to the GDPR. We will now talk one by one about them with the examples of their application in your as notaries daily work. So they're actually regulated in the GDPR itself in the articles 12 to 22. I will not provide all the exact formulations of these rights in my slides, because I feel that if you try to read what is written in the slides, then you might lose the focus on the things that we are discussing and my words that I'm saying. So if you need to go into details how it is really regulated, how it's written in the law itself, you can just simply open the GDPR itself and try to see how they are regulated in the articles 12 to 22, as I mentioned. The first right we are going to discuss is right to transparent processing and right to information. We already heard about the basic principles of the GDPR in today's presentations. One of the basic principles that are really, really important is the transparency. So what does transparency mean in this context? So GDPR says that a data controller, this means that a notary as well as any other data controller shall take appropriate measures to provide any information referred to in Article 13 and 14, which means that information that is processed by a data controller, it shall provide this information to a data subject in concise, transparent, intelligible, and easily accessible form using clear and plain language. So information should be provided in writing or by other means, including where appropriate by electronic means. So when requested by data subject, the information could be provided orally, provided that the identity of the data subject is proven by any means. So how can a notary ensure this principle and this right to the data subject? So first of all, most of you notaries have the websites where you provide information about your contact details and about your actions, etc. So you could definitely upload your privacy policy or your internal rules of data processing into that website that you have. So simple, really one-way solution, simply one-click solution that you will definitely provide information to your data subject how you process this data. You can also make it available in your waiting room, for example, put it on the board, making a hard copy on your journal table, and it would be definitely accessible to anybody who's there in your office trying to make any kind of notarial action. This means that you provide information in a transparent and really accessible form. You provide it to anybody who enters your office. What you also have to do in terms of transparent processing and the right to information is you definitely have to provide video surveillance notices to the ones that are entering your office in case you are performing video surveillance. I know that most of the notaries do have video surveillance means in their office. What you have to do is provide it by notices. And I saw that in your internal, the chambers, notarial chambers approved version of your data processing rules really has this exemplary notification regarding your surveillance. So if you want to use that form, you can definitely access it, and it's really available to you, and it would be really beneficial to have such a notice on your entrance to the office or near the camera that is there in your office. So just make sure that it's visible, it's clear, it's written in a plain language, and it's really accessible to all entering your office. And surely the other means of how you can provide information transparently, openly to all the subjects is you can provide it verbally or in a written form when you're already processing and providing the specific notarial action. So you can provide a copy of your internal rules for them to acknowledge and to see how data processing is really working inside your office. So this is actually a very simple right, and it's really, really important that you provide this transparent information in simple, easily understandable words to all of your clients, customers, or any interested parties that enter your office. The second right we are going to discuss is the right to access information. So a data subject should have a right to access to personal data which you have been collecting concerning him or her, and to exercise this right easily at reasonable intervals in order to be aware of and verify the lawfulness of the processing. So every data subject should have the right to know and obtain the information, in particular with regard to purposes for which the personal data is processed, where possible the period for which personal data is processed, the recipients for which personal data has been provided, also if there's some kind of a profiling, so the logic under which this data processing and profiling is taking place, consequences of such processing, etc. So there is a list of this information. I can go on with it, but you will definitely find it inside the GDPR. So it's the existence of right to request the information from the controller, also a right to lodge the complaint, the existence of automated decision making if there's any in your activities. So there is a list of information that a specific person can access from you that you have to provide in case the person asks to provide information to him or her. So this is theory. What does it mean in practice for the notaries? So in practice, for the notaries, it means that, for example, if a person comes and asks, give me all the information you have, including all the wills I mentioned in, all the my name mentioned in, etc. So could you do that? Would you do that? And can you do that according to the law? So the only thing that a notary can provide in such a case is information that does not contradict to the confidentiality of notarial acts. So we all perfectly know this concept of notarial secrets, and we all perfectly know the Article 14 of the law on notaries, which says that the notarial confidentiality of notarial acts should be assured in any case. So notaries must ensure the confidentiality, and, for example, certificates concerning notarial acts and documents shall only be issued to legal and natural persons on the instruction of whom the notarial action was performed or their legal representative. I'm perfectly aware of this regulation. So certificates concerning wills shall be issued only after the death of the testator. This doesn't mean that the person can come and ask, well, am I in the will of my grandma who's about to pass out or something like that? We cannot do that. We can only do that when the person is already entitled to receive the specific will. Also, you know, the professional secrecy, you do not disclose the facts that are part of notarial secrets. And what is said in the practice is that notaries shall, at least, well, this is the minimum, what we have to ensure is we can disclose that information about him or her is actually processed within the specific bureau or not. So this is all you can see. You cannot see where it's processed, how it's processed, who mentioned your name in which document. The only thing that it says in the practice is that we can see, yes, your name is processed, or no, I don't have any information about you. And also, this right means that sometimes when a person asks, we would have to provide a copy of the documents containing his or her personal data. So it actually is a very interesting law, as it really depends on the volume. For example, once a year, the law, the theory says that once a year a person should be entitled to receive a copy of his or her documents. But I understand and I know that in notarial practice there is this practice that we are providing duplicates for certain specific amount of remuneration, right? And in my opinion, this right to receive a copy of your documents, of your personal information, could not be used as a way around this receiving a duplicate of your document. For example, you lost a document, you're going to a notary office saying, well, give me a copy of everything you have about me, and then you will receive a duplicate of the information or the document that the notary has. If a person wants a certified document, a certified copy of his or her agreement or a will, etc., it has to be a certain amount that covers the exact and actual costs of issuing of such documents. It's providing a duplicate is actually a notarial act, not ensuring that the protection rights are made available. And if a person asks for processing of copy of his or her documents more than once in a year, you as notaries may charge a reasonable amount of fee based on administrative costs. How really much it costs, definitely for copying costs, etc. Administrative costs, way should be if a person wants to enjoy this right many times a year. Sometimes there are some people who are really just trying to implement their rights not because they need some kind of information, but because they just want to annoy you or make some more encumbrances for you. So in these cases, you definitely can charge some amount of reasonable fee that covers at least your copying or your administrative fees. And I see that in the chat we have some. In the chat we have saying that we shall a bit take it slow because maybe the translators are having a hard time to translating it. So I will try to be more slow, taking from further. I hope it's clear up until this part. And if you have any questions, I really encourage you to stop and ask the questions or put them in the chat box if you have any kind of questions or maybe some points to discuss, maybe an open discussion among ourselves to make this whole thing clear. So going to the next right, which is right to object. Next slide, right to object. So the data subject shall have the right to object on grounds relating to his or her particular situation at any time to processing of personal data concerning him or her. So in such case, the controller shall no longer process personal data unless the controller demonstrates compelling legitimate grounds that this processing overrides the interests, rights, and freedoms of the data subject. So this is the theory, right? So we need to enjoy the right of data protection, which is like right to object. But what does it mean in practice, and specifically, what does it mean in notarial practice? It is said that a person can object to processing of his or her data in case the obligations overrides the person's rights and interests. So, for example, in case of a credit note in Lithuanian vexels, so that not be lost in translation, right? So in case of a credit note, a person may not say, I object, for example, to processing of my data, and please do not process my data as a debtor because I object to such process. In any case, notary has to perform certain obligations that he's entitled to, and there is no way that a person can, cover himself with this right by trying to somehow, avoid his obligations according to the credit note. Or the other example in your practice would be a person says, he or she gives like cash, which is more than 15,000 euros. And the person says, please do not transfer my information to Financial Crime Investigation Bureau. But this is actually a part of your job. In such a case, the person can object all he or she wants. If you have an obligation according to the law, this is what you do as a notary. You cannot listen to a person who says, please do not follow the law. You just have to do it, and there is no way the person could avoid his or her obligations in such a case. So let's move on. The other right is the right to limitation of processing. So again, let's talk about theory and then let's talk about practice. So the theory says that the data subject shall have the right to obtain from the controller restriction of processing where any of the conditions applies. For example, when the accuracy of personal data is contested by the data subject for a period enabling the controller to verify the accuracy of personal data, or where processing is unlawful and the data subject opposes to such process, or when the controller no longer needs the personal data for the purposes of the processing. So in these cases, the restriction of processing should be granted. But in notarial practice, let's speak about practice, I believe that this is one of the least used rights, and it's probably used in really little number of cases. One example I could think of is the person, for example, is saying there is a mistake in the register, there's a mistake in some kind of record of state enterprise registers in the extract, and he takes actions towards rectifying these mistakes. And in the meantime, he or she says, please do not rely on this information because this information is being rectified, this is not accurate, this is not true, and provides relevant proof. So in such case, I believe it's really normal to restrict the processing, not to go on carry processing activities, and to restrict the processing for a limited period of time when we need, in the meantime, we need the information to be rectified. And then when that information is already rectified, it's really accurately described and reflected in the registers, then we can continue the processing. There's also this right to rectification. This example is also related to the one we just discussed. So in theory, the data subjects shall have the right to obtain from the data controller without the undue delay the rectification of inaccurate personal data concerning him or her. Taking into account the purposes of processing, the data subject shall have the right to have incomplete personal data completed or inaccurate data corrected, rectified, etc. So in practice, in case a person comes to a notary with such a request, the notary can request for documents to prove such request, that this request is really lawful. And in such case, the notary shall also notify the data recipients, meaning the ones they have transferred the data to, if that is really possible. So the person shall also have the right to know to which person the data has been transferred and ask for rectification as well if the data has been transferred to other data controllers or other subjects. Moving on, the right to data portability. And again, firstly, the theory. So the data subject shall have the right to receive personal data concerning him or her, which he or she wants to provide to the other controller in a structured, common use, machine-readable way, so that he or she can take the information and give it to some other controller for further processing. So here's the theory. And in all the cases, as I've mentioned before, theory is one thing, and in practice, it may mean totally different things. So it's really highly complex. Actually, the idea when GDPR was being drafted, and at the beginning when GDPR came into force, the idea was of this right was, for example, I have a clinic which takes care of my health, right? So I have the whole medical record here. I have all the information at a specific clinic or at a specific doctor that takes care of my health. And then I want to switch to the other clinic. I want to go to the other doctor, but I want the new doctor, the new clinic, to know everything about my health, so that he or she would continue my processes of my healing, of my surveillance of my health conditions, etc. So what I can do is request for all my health history from that specific clinic to be transferred to the other clinic, and the processing of my personal data continues, so as my healing continues. Right? The same about, for example, banks. I know I have all my spending history at one bank that I have been a client to, and then I want to switch the bank. I want to move to a different account. And then I take all the history of my spending to the other bank, and he or she knows that, well, this is what my current income is, this is how I spend the money, and this is how my bank account looks like. In case of notaries, in case of notarial practice, I have a really hard time finding a good example when and how this right could be used. It is easier to say what you can do. So you can't give the physical file or archives to the other controllers or to the same data subject itself. But this is what you have to keep according to the laws, so it does not apply to archive files. Maybe one similar thing that you are definitely doing in your notarial practice, similar thing is, for example, when a person comes, he or she has like inheritance file right in your notarial office, and he or she wants this file to be taken by another notary to bring it to another city, which is more convenient to him or her, etc. Right? So maybe this is the closest example that I could think of is taking the inheritance file to the other notary. But even in this case, this does not mean that you take the whole file and bring it to the other notary, right? This means that the notary shall have just the copies of the documents sent, transferred, but it doesn't mean taking the whole file out of you and bringing it to the other notary, because you still have the rights and obligations to keep the information that this particular file has been at your office and that you have already been processing this information related to inheritance. So maybe this could be a good example, or maybe not. This is not actually the specific data protection right that you have in this law, this inheritance file transferring to another notary, but this is probably the closest example I could think of. Maybe you have some other better examples of practice, and I would really together. So, moving to the last right, right to be forgotten. Actually, it's quite a funny too. When GDPR came into force, a little bit of history, some bad guy said, okay, now I'm going to the police, to the enforcement agencies, to all the courts and all the general prosecution offices, and I'm going to say to them, I'll forget it. And actually, it's not the case, and it didn't happen, and it will never happen in any case. You cannot forget a person if we have other legal grounds to further protect his or her data. So this right to be forgotten, as I mentioned in the beginning, these rights are not absolute, and we have to take into account also other laws that surround this processing. So right to be forgotten is not an absolute one, and if we have other legal grounds for processing of such data, we cannot forget the person, and we have to do what's written in the laws. So the law, the theory says that data subject shall have the right to obtain the erasure of personal data concerning him or her without undue delay, and the controller shall have the obligation to erase data without undue delay, where this data is no longer necessary in relation to specific purposes, also where the data subject withdraws consent on which the processing is based, or when data subject to such processing, or where the data has been unlawfully processed. So this means that we know that there is no legal ground, and the person asks, well, please forget about me because you don't have a right to process such data. In this case, such could be granted. But if you have a consent and a person says, like, forget me, then what we have to do is we have to check if we do not have other legal grounds for processing of such data. So let's remember this example that we already talked about, this credit notes, this vexelis in Lithuanian. And actually, there was this one court case that I managed to find. It was in a Lithuanian court practice. And there are no similar court practices that I could find in Lithuanian or in European case law. So this only one case, and I will briefly tell you about the facts of this case. So the situation was that a person applied to a notary and to the Lithuanian Chamber of Notaries for the removal of his personal data from the public register of these protested bills of non-payment. It was published publicly available. It was made publicly available in notarų rūmai.lt website, in the info registry, specifically designed for announcing the credit notes, the vexel information. Both the notary and the Chamber of Notaries refused to delete this information, and definitely the data subject went to the authority, to the State Data Protection Inspectorate, and asked to oblige the notary and the Chambers of Notaries to take out this note, to delete this information from the state register. And the inspectorate, the State Data Protection Inspectorate, said, well, this request was unlawful and we shall not grant it. But when taken to the court, actually the court said that there is no specific data retention period and no term how long this information must be kept in the public register. But even if national law does not provide for this, and if there is no clear term on which the data shall be processed, GDPR must be followed and data should be removed when legal basis for processing disappears. And in that case, the data was published in when the non-payment was still there, but the person subsequently paid the debt and no longer was in debt. Therefore, the court said it doesn't no longer require processing. Therefore, this information shall be taken out from the publicly available records. It's no longer relevant. The person is no longer in debt. So this was the court case. Even if we know that we have the right to upload this credit notes to official registers, but the person already paid the debt, this means that processing is no longer required and this information should be taken away from the register. So these are all 7 rights. Yeah, I'm sorry for being a bit rush in the beginning. I was really willing to put my all in 1 hour, put all material in 1 hour. So hopefully we will make it, because the only thing that is left is how do we do it? So how the process of implementation of data subject rights look like. So usually the request of data subject should be written. So what does it mean? It means that if a person comes to your office and says, now I want everything that you have about me, now please, for example, forgive me, or I want to enjoy any of the rights that I have just mentioned in the presentation, what we can do is to offer them to sign a form. You have this form approved also in the Notary Chambers model document, which is related to data protection or internal model rules of data protection in the notary offices. So there is this form. If a person doesn't bring some kind of request by himself or herself, we could give them this form and ask them to fill it in. So it should be provided to you by appropriate means. This means that it could be provided to you personally, or by post, or by email, or by courier. And appropriate form should be followed. So it should be written in local language, it should be signed by a person, and the request should be made clear. It means that the person should say what he or she really expects from you, which rights he wants to enjoy. So you have to be clear, you have to understand what the person really wants from you. It doesn't mean that if a person brings a request in a different form that it is approved by the Chambers of Notaries, it doesn't mean that you reject it and say, well, this is the form that you have to fill in. If a person brings the request that is readable, it's understandable, you can see what a person really wants, it's in Lithuanian language, it is signed, you have to accept it, and you cannot deny granting it just because the form is not the one that has been approved by the Chambers of Notaries. We have to do as a next step, when we evaluate if the form is really right, we have to identify the data subject. So in case the request is given to you personally, the person comes and gives you this request as a written form, you have to check, you have to ask to provide also the ID of the person, just to make sure that the person who is submitting is the right person and he has the right to get this information. If the request is submitted by post or by courier, we have to request to provide a copy of ID. If, for example, we see that this information is not provided, we cannot say, well, this is a formal ground to reject that. What we have to do is to request for additional identification data or documents. We just have to simply ask for submission of a copy of ID, or, for example, ask that a person that comes to your office and shows you the ID so that you could proceed with further examination of such requests. If the request is submitted by electronic means, it should be signed by electronic signature, which is certified or otherwise qualifies as electronic signature. If we identify and we know what the person really wants, so what is left for us is to implement such requests. So this could be done directly to the person, or if the person wants to get this information by representative, for example, he or she asks, or please provide this information to my attorney or to my successor, or whoever he wishes the right to be implemented to, then we can do it not directly to the person, but to his or her representative. And also, as I mentioned in my presentation before, we have to definitely deny it in case it contradicts to other laws or professional secrecy of and if we see that the person requests for more information than we can provide to him or her according to the laws, we have to deny this request and not provide the information that term in which we have to respond to this request is 1 month. There is a possibility to extend it up to 2 months, but there should be reasonable grounds for such extension. For example, if the information requested is really extensive, if the requires for implementation of 5 rights instead of simply access to information. So if we need to somehow collect more information, or if we need additional time, so this is when we extend the time. But this extension is more of an exception, not a rule. So in any case, we would have to try to provide this information in 1 month period of time. And as I mentioned previously, we have to provide this information free of charge. We do not have to charge for implementation of rights unless, as I mentioned before, unless a person requests for a duplicate of certain document or implementation of any additional notarial acts that have not been performed before. So in this case, we charge normally, but usually implementation of the rights have to be provided free of charge. So it seems simple in this theory, in these charts, but the ones who already received such a request know that it's really, really complex. It might be really difficult to implement such requests, because usually the person asks for a lot of details, like, for example, who have you been giving my information to? So this means we have to go back to the file and see what was there more in the file. We also would have to check if the person has the right to receive this information. So we have to check all the documents and see what the notarial act was about. So was the person attending himself or by representatives, etc., etc. So it's not that easy as it seems. So the ones who already received such requests probably know what I'm talking about. And you can definitely expect this whole month of drafting the response, because it could be complex. Definitely, if a person has one similar small thing, it might be less complicated. But usually, these requests take a lot of time and a lot of effort. We want to provide all the information according to the laws. Coming back to the introduction, I'm almost finishing my presentation. So shall we see GDPR as, and especially the rights of data subjects, as threats or aggravations? Or shall we see it as business as usual with the only aim of balancing the rights and obligations of you as data controllers and your customers and clients or any other data subject? So I hope I made my point clear today that there is nothing to be afraid of. And the only thing we have to do is we have to act according to the laws, just like we usually do, just like you, your notaries usually do. So to sum up, there is a number of rights we have to grant data subjects, namely a right to transparent data processing and right to information, right to access, right to object, right to limitation of processing, right to rectification, also right to data portability and right to be forgotten. So these are the main rights. But none of these rights, as I mentioned, are absolute. They have certain limitations, they have certain conditions. And when granting such rights, we have to take into account the existing regulation and notarial secrecy, in particular, confidentiality of notarial actions. Therefore, in any case, when considering the data subject request, please consider whether there is a legal ground for granting such rights and make sure you act in accordance with law applicable in notarial practice. So this is what I wanted to tell you today. I really appreciate your attention. Thank you very much. And I know that there is one small video also waiting for you at the end of my presentation. So I think that this is about time we switch to that video. And if you have any questions, I'm always willing to respond and to advise if there are some problems or if you have any issues in granting the rights to your data subject. So thank you very much for attention, and I hope that it is as easy for you as balancing those stones and rocks, and just try to stay in line with notarial regulations, and I think everything is going to be fine. You do not have to fear it. We just have to face it as a usual practice. And I think that it has been almost 4 years when GDPR is in force, and we are slowly getting there to the phase of acceptance that we know that we have to grant such rights, and we are not afraid of it anymore, and this is what I wish.
Dėkojame gerbiamai Miglei už jos iš tiesų išsamų pranešimą. Labai atsiprašome už iškilusius techninius nesklandumus ir kviečiu Jūs padaryti trumpą pertraukėlę tarp pranešimų ir pasižiūrėti antrą Europos Sąjungos notariatų tarybos parengtą informacinį video reportažą apie asmens duomenų apsaugą.
Les personnes concernées, c'est-à-dire les personnes dont les données sont traitées, clients ou collaborateurs, disposent en vertu du RGPD de plusieurs droits qui sont susceptibles d'être exercés à l'égard du notaire. Parmi ces droits, nous pouvons citer le droit à un traitement transparent, le droit à l'information, le droit d'accès, le droit de rectification, le droit à l'oubli, le droit à la limitation du traitement, le droit à la portabilité des données et enfin le droit d'opposition.
Parmi ces droits, concentrons-nous sur le droit à un traitement transparent et le droit à l'information, ainsi que sur le droit d'accès des personnes concernées. Il s'agit des droits auxquels les notaires sont les plus susceptibles d'être confrontés. Les traitements réalisés dès l'ouverture d'un dossier sont somme toute légitimes dans le chef du notaire. Ce dernier est dans ce cadre tenu par une obligation d'information à l'égard des personnes concernées. En effet, le citoyen a droit à ce que l'étude traite ses données à caractère personnel de manière transparente et dispose en outre d'un droit à l'information. Ainsi, le notaire doit expliquer clairement au citoyen quelles sont les raisons pour lesquelles il est amené à récolter les données à caractère personnel le concernant. Quelles sont les bases légales applicables ou encore quels sont les destinataires des données.
Il est intéressant de savoir que cette obligation d'information s'applique en toutes circonstances, et donc même si le traitement est autorisé par ou en vertu d'une loi, à tout le moins lorsque les données sont récoltées directement auprès de la personne concernée. Ainsi, lorsque ces données sont collectées directement auprès de la personne concernée, le notaire lui communique les modalités des traitements de données. Quelles sont les finalités poursuivies, les destinataires, la base de licéité, les durées de conservation, et ce, au plus tard, au moment de la collecte.
La méthode d'information est laissée au libre choix du notaire, pour autant que le langage utilisé soit clair et compréhensible et que l'information soit aisément accessible. Afin de remplir cette obligation, le notaire rédigera une politique de protection des données qu'il remettra à ses clients lors du premier rendez-vous, qu'il publiera sur son site internet ou encore qu'il rendra accessible dans sa salle d'attente, par exemple sous la forme d'une affiche. Il pourra également ajouter en lien vers cette politique dans sa signature électronique et celle de ses collaborateurs.
Le citoyen peut à tout moment obtenir la confirmation auprès de l'étude du fait que ces données à caractère personnel sont ou ne sont pas traitées. Notons que le droit d'accès est certainement un des droits les plus utilisés à ce jour par les personnes concernées à l'égard des notaires. Le notaire, à l'origine de la recherche, est alors tenu de communiquer à la personne concernée les informations suivantes. Les raisons du traitement de données, c'est le principe de finalité, les catégories de données à caractère personnel concernées, les destinataires, leur durée de conservation, le cas échéant, l'existence d'un droit de rectification ou d'effacement, et enfin, la possibilité d'introduire une plainte auprès de l'autorité de contrôle.
Si le notaire ne peut pas répondre à la demande du citoyen, par exemple parce que celui-ci est un bénéficiaire testamentaire qui se renseigne sur les recherches effectuées à son égard, il l'en informe et explique les raisons de son refus, en l'occurrence le secret professionnel. Le notaire doit au moins mentionner le fait que le citoyen est concerné par un des dossiers dont il est chargé.
Taigi, pereiname prie kito mūsų pranešėjo, profesoriaus Dariaus Štitlio. Jis mus supažindins su bendrojo duomenų apsaugos reglamento nuostatų taikymų praktikoje ir kibernetinio saugumo temomis. Pranešėjas pirmojoje dalyje pristatys asmens duomenų apsaugos praktikoje ir kibernetinio saugumo teoriją.
GDPR in practice and cybersecurity, and in his next theme he will invite you to engage in practical tasks. As far as I know, he is already with us online.
Can you see my screen?
Jūsų skaidres matome.
Do you hear me well?
Girdime, viskas puiku.
Okay, thank you.
Yes, we can.
We can start with the GDPR in practice and personal data security and cyber security. Let's start from GDPR compliance. What is important? Just a minute. What is important for GDPR compliance, including the security side? Yes, GDPR documentation is necessary, but documents alone are not enough. In addition, provisions of GDPR documents are often out of practice and ineffective. This is called formal compliance. Also very important is organizational culture that starts with the view of the management, of organization management. A lot of depends on the tone set by the management and the example shown. So in other words, when we have notary office, so a lot of depends from the notaries itself. understanding the security threats of the organization, its individual members, also very important. Thus, the organization needs to conduct personal data security training, during which should provide many examples and explanations, such as what phishing is and how it occurs, how to recognize it, and so on. And also, the third one, how to establish appropriate procedures. So, procedures and processes that are in practice are very important, including the procedure for reporting, assessing, and communicating personal data breaches. And only the sum of these elements can ensure real GDPR compliance in practice. Not only GDPR documents, but also, as I said, culture of the organization, processes and procedures that are in place. And now, accountability principle. The Article 5 of GDPR defines 7 principles relating to processing of personal data, which are from the backbone of GDPR and the data protection law in general. And all principles are important, but in practice, there are often questions about implementation of accountability principle. And a few words about accountability principle. It is one of the main principles in data protection law, and it makes data controller, also data processor, responsible for complying with the legislation, with the data protection requirements, and says that data controller must demonstrate compliance. Requirements also, accountability principle requires both data controllers and processors to actively and continuously implement measures to promote and safeguard data protection in daily life activities. And measures should be appropriate to the risks. And accountability enables you to minimize the risks of what you do with personal data by putting in place appropriate and effective policies, procedures, and measures. These must be proportionate to the risks, which can vary depending on the amount of data being processed, its sensitivity, technology use. For example, if you use mobile devices to access personal data, this should be evaluated in terms of risk assessment. For example, when considering an electronic system in Notary, we need to think about secure connection to such system, to personal data. Accordingly, we need to assess the risks to the data subject's rights and the level of secure access required. And controllers must be able to demonstrate compliance not only with data subjects, but also general public and, of course, to supervisory authority at any time. Processors must also comply, but their accountability obligations are a little bit different. For example, they have obligation to keep records of processing operations, to appoint DPO, etc. But data processors do not have the same level of GDPR compliance responsibilities, because main compliance responsibilities lie on data controllers. and notaries as data controllers should know this principle. About practical problem, data controllers usually do not provide sufficient information or evidence in response to inquiries from the supervisory authority, which could be considered as a breach of accountability principle. So, very important when data controllers receive any request from supervisory authority to answer the questions taking into account accountability principle, which means, as we already talked, that data controller should demonstrate compliance. For example, if the controller is asked to provide information on legal basis for the processing of personal data, and this basis is, let's say, legitimate interest. Let's say, an example, Lithuanian supervisory authority expects a balance that's to be provided to the authority. Otherwise, a breach of the accountability principle could be established. So it's very important to respond to any inquiries of supervisory authority, providing as much information as we can. And here we have self-questionnaire about accountability. From this list, we can see that key measures need to be taken by data controller. And I will try to quote this list. For example, we take responsibility for complying with GDPR at the highest management level and so our organization. So what does it mean? So, all organization should be involved in complying with GDPR principles and other legal norms. We keep evidence of the steps we take to comply with GDPR. For example, if we conduct data protection, some seminars or other activities, so we should we should keep evidence about this activity. We put in place appropriate technical and organizational measures, such, for example, adopting and implementing data protection policies, taking data protection design and default approach. What does it mean? So if you have any, for example, if the notary system as such has a new project, for example, e-notary, so data protection by design and by default principle should be taken into account. For example, we should think about data protection from the very beginning of the process of the project and through the whole implementation of the system. Putting written contracts in place with data processors. For example, if the notary has any data processors, for example, any firm that organizes, for example, financing issues, so there should be written contracts with that firm. Maintaining documentation of our processing activity, implementing appropriate security measures. We will speak about security measures a little bit later. Recording where necessary, reporting personal data breach, carrying out data protection impact assessment. We will talk as well about data protection impact assessment. Appointing data protection officer, and etc., etc. So there are a lot of measures that should be taken by data controller. And of course, the last but not least, we review and update our accountability measures and at appropriate intervals. So what does it mean? So when we have, for example, new documents, they should be reviewed after, for example, 1 or 2 years. So let's have several examples. The first examples about accountability principle. The first example is about PricewaterhouseCoopers company. This example, of course, is related with non-compliance with accountability principle. The Greek Data Protection Authority imposed a fine of 150,000 euros on Pricewaterhouse Greece company in 2019. And the employees of this company were forced to sign a statement of acceptance of terms of personal data, and consent was not freely given. The fine is for violating the principle of accountability under the GDPR Article 5 for not being able to provide internal documentation of its choice of legal basis. Why I do not provide examples about notaries' activities and fines? Because in Europe we have, for example, page enforcementtracker.com, and I tried to search notary, for example, keyword notary, but there were no results. So we can discuss only about examples from other areas. And the second example is related to Lithuanian fintech company. The Lithuanian DPA imposed an administrative fines in 2019 in the amount of 61,050 euros, and on joint stock company, Mr. Tango, a payment service provider, for, among others, the breach of Article 5 of the GDPR. And it was determined that the company processed more personal data than was necessary for affecting the payment. For example, a number of issued payment cards, topics of submission, and etc. The DPA considered that the company breached the principle of data minimization, the first one. Furthermore, it was determined that the company stored the data longer than it had established and indicated as necessary by itself. For example, 216 days instead of 10 minutes. Let's imagine data was being stored 216 days instead of 10 minutes, only 10 minutes. Therefore, it was considered as breach of principle of storage limitation. And finally, the company also failed to provide sufficient evidence as regards its compliance with the data protection principles during the investigations. So therefore, breaching the principle of accountability. So the company did not cooperate with the Lithuanian Data Protection Authority. Thus, the failure to provide information to supervisory authority or insufficient information may be considered as breach of the accountability principle. And the third example, the third one, it's a German example. German authority issued in 2021 a fine of 300,000 euros on the soccer club Stuttgart for neglectful breach of the accountability principle under Article 5 of GDPR. The club just transferred several tens of thousands of personal data of club members to an external service provider, and the club failed to provide a contractual basis for its cooperation with the service provider. And I think that this service provider was from China. So the authority decided that there was a violation of the accountability obligation according to Article 5 of GDPR. And this was based on the fact that due to insufficient documentation of the contractual relations, relationship with the external service provider. Of course, we have a lot of examples from all the European countries, but let's say we can talk about several of them. And in this slide, we can see that the principle of accountability is often violated together with other principles of the GDPR. Now, there are only 4 examples. The newest examples for 2021, end of 21, year 21. For example, Italy, it was fined for non-traceability of the calling numbers. It was related with direct marketing, and the data controller was not able to provide to whom they called and what was the number of calls. So non-traceability of the calling numbers, and they also did not provide information who is calling. So this was as a breach, treated as a breach of several principles, but of including accountability principle. Another example is from Poland. We see Warsaw University of Technology. The university was not able to demonstrate compliance regarding security measures. So it's very important in practice, and we will talk a little bit later, not only have security measures implemented, but to demonstrate implementation of those security measures. This set example from Romania. This issue is related, for example, a complaint made by data subject claiming the receipt from the telecom operator of some invoices and notification messages regarding related with another person, a subscriber of the same company. And operator has incorrectly collected and processed certain inaccurate personal data, which was also led to the illegal disclosure of personal data to another individual, and which is a violation of the principles of personal data protection, including principle of accountability. And of course, we have a lot of similar examples when accountability is only one of the principles that were breached in the case of several cases. The next slide. So we can move to the records of processing activity. Records, it's an obligation coming from Article 30 of GDPR, and we see that record is a document with inventory and analysis of purposes, which must reflect some information among other about the actors involved, about categories of data processed, about purposes of data processing, who has access, what are the recipients of data, for how long the personal data are retaining. Also about technical and organizational security measures. And the records of processing activities, it's an internal document required by the regulation and is mostly commonly used to demonstrate compliance to the data protection supervisory authority. And there are records of processing activities must be kept both by data controllers and data processors. We can see that the content of the records of data controller and the data processor is different. If the data controller has to fill in more information because he's responsible for processing of personal data, the controller also has to show more on who's the processor on the next slide must show on whose behalf he is processing personal data. So here we see requirements for data controllers records, and in the next slides we can see requirements for data processor records. For example, on whom behalf we can process data, what type of data we process, what security measures we implement, etc., etc. And usually, the requirements to have data processing records is also indicated in a written contract between data controller and data processor. In this slide, we have an example that, for example, entries can be made simply in Excel form, entries to records of processing activity. But the records can also be filled using automatic tools, special programs. And here we have some example of such programs or applications. Some of them we must pay for some of them. So there are also perform other functions, for example, such as data inventory function or function related with privacy impact assessment. But one of the functions is exactly data processing records. And in practice, the records may be completed by the data protection officer or by other responsible person for such function. Also, from the practical point of view, aside from being an obligation settled by Article 30 of GDPR, the record is an internal control tool, and as I mentioned above, and a way to demonstrate compliance with GDPR. It always it allows you to document your data processing and to know what questions you must ask yourself before and while processing data. So it's a very good tool to control and to think about data processing operations and personal data you are processing. For example, do I really need certain data for this specific purpose, for this specific processing? Is it relevant to retain all of this data for so long? Are the data sufficiently protected, and etc. And creating and updating the records is very important function. This essential step will allow you to delineate an action plan of your processing complying with data protection rules. And here we have data protection impact assessment. Data protection impact assessment is some systematic method for assessing and documenting relevant data processing activity in order to answer questions regarding risks to data subjects. So the main issue with data protection impact assessment is that this is like a risk assessment, just risk assessment. And GDPR, as we see in the slide, is a process to help you identify and, of course, not only identify, but to minimize the data protection risks of a project or processing operation. So the task is not only to identify the risk, but to have measures that mitigate those risks. And GDPR mandates that the data controller conduct data protection impact assessment in certain circumstances. So it's an obligation for data controllers, not for data processors. But data processors, if the activity is related with appropriate data processing task, so they should help data controllers to conduct a data protection impact assessment. Also, you must do a data protection impact processing data protection impact assessment for processing that is likely to result a high risk to individuals. So the criteria is a high risk to individuals. And the question is how to know where we have or where we will have a high risk to individuals. The answers will be in next slides. Thus the data protection impact assessment does not have to be carried out on a case-by-case basis, but only in cases where processing of personal data poses a significant risk to data subjects. And here we have an example of self-monitoring questionnaire. The questionnaire helps to assess the risks of the data subjects of a project, for example, and helps to decide where an impact assessment is required. For this purpose, appropriate criteria are used, and they are presented in my next slide. So we can see the criteria, 9 criteria, the old directives, data protection directives working party of Article 29 has named 9 criteria for processing operations that might lead to an assessment if at least, so the main rule is if at least 2 criteria are met, so data protection impact assessment should be conducted. Sometimes 1 criteria is enough, for example, processing of sensitive or highly personal data. Sometimes it's enough only have 1 criteria. But basically, the basic rule is when we evaluate a new project and analyzing those criteria, it is enough that 2 criteria are met, and in this case, obligation arises to conduct data protection impact assessment. And Article 35 of the GDPR provides that each supervisory authority must establish and publish a list of the categories of processing operations which are subject to data protection impact assessment requirements. For example, France data protection body has published a list of categories for data processing operations that require data protection impact assessment. And here we have types of processing operations, and on the right we have criteria, and we see that at least 2 criteria are met. Sometimes 3 criteria are met. So this is list, also called blacklist of processing operations that require data processing impact assessment. And the same situation is in other countries. For example, Lithuanian Data Protection Authority also approved a similar list of data protection operations that require data processing impact assessment. And the main rules is as follows. The fact that personal data protection operation is not included in the mandatory list does not mean that an impact assessment is not required at all, because it may be needed to analyze those criteria, those 9 criteria, and maybe some of the criteria are overlapping. So sometimes data controllers decided to carry out impact assessment based not only on the obligatory list, but on those 9 criteria. But in practice, there are also such examples when data controllers decide to carry out impact assessment on his own initiative in order to identify and manage risks of the project. For example, yes, we can analyze the obligatory list, and there is no such operation in the list, and there are none of criteria met, but we want to analyze risks of a project. So we decide to carry out impact assessment in our initiative. So this is also possible. And here we have steps of data protection impact assessment or cycle. A data protection impact assessment should begin early in the first step of the project, before, for example, you start your processing activities, and run alongside the planning and development process. And it should include these steps. We can start with identifying needs of data processing impact assessment. Later, we describe the processing. It's a data inventory, in other words. Later, we consider consultation, assess necessity of proportionality, identify and assess risks, identify measures to mitigate risks. We record, of course, outcomes and integrate outcomes in a plan, and of course keep under review our data protection impact assessment. So, of course, data protection impact assessment is also one of the practical implementation of principle of accountability. And it's a very good tool for the controller itself to identify and manage data protection risks, risks to data subject rights. And now we can see that there are some templates. This template is coming from France. Of course, Lithuanian Data Protection Authority also adopted some recommendation about privacy impactment, how to perform privacy impactment assessment. And the most common problems in practice there are as follows. When data controller does not realize then that evaluation is required and no evaluation is being carried out. Yes, there are some such cases where data controller just do not know that he has obligation to perform data protection impact assessment. Also, another problem is maybe related with incorrect indication of risks. I saw a lot of, quite a lot data protection impact assessments in practice with non-correct indication of risks. The risk were of general nature and not related with appropriate projects. And our Lithuanian Data Protection Authority also says that one of the risks when carrying data protection impact assessment not to indicate appropriate risks in the assessment. And another problem is no residual risks indicated. So when we have the initial risk, we should think about what measures should mitigate this risk. And later on, we should evaluate what is the residual risks. And the last but not the least practical problem when the assessment is carried out by the data protection officer, DPO, because DPO only has to, according to GDPR, only has to advise or consult in the process of data protection impact assessment. But we have in Lithuania, especially, a lot of cases when a DPO directly conducts data protection impact assessment. This is a breach of GDPR also. And here we have, today I'm providing a lot of examples from France. And this is another example. And here we have application created, initiated by France Data Protection Authority. This application is automatic tool which helps you to conduct data protection impact assessment. And this tool is for free, and you can download at any time this automatic tool and just to try to conduct data protection impact assessment. Some of the specialists, they just learn from this tool how data protection impact assessment should be conducted. And let's talk a little bit about data protection officer position. So the primary role of the data protection officer, of course, is to ensure that organization processes and the personal data of its staff, customers, providers, or any other individuals is in compliance with the applicable data protection rules. And here we see the main tasks of DPO defined in Article 39 of GDPR. And we can see to inform, to advise employees about obligations coming from GDPR, to monitor compliance with GDPR, to raise awareness of data protection issues, so training activity, staff training activity, conducting internal audits, also to advise and to monitor data protection impact assessment, as we talked already, not to conduct, but only to advise and monitor, to cooperate with supervisory institutions, and of course to be first point of contact for the supervisory authority and for the data subjects. And data subject could be, as you already know, internal or external ones. And position of DPO, it's like a health questionnaire that helps you to evaluate if everything is okay with the position of DPO. For example, our DPO reports directly to our highest level of management and is given the required independence to perform their tasks. We involve DPO in all issues relating to the data protection of personal data. Our DPO is sufficiently well resourced to be able to perform the tasks and functions. And of course, to ensure that any other task or duties we assign to our DPO do not result in a conflict of interest with their role as a DPO. For example, IT specialist who implement security measures could not be a DPO because he will control itself how he implements security measures. Very important, what is very important in the daily life of the DPO's activities, proactivity, initiative, participation in the meetings regarding personal data protection, regarding any projects related with data processing. So involvement in the projects from the early stages, involvement in training. Of course, annual reports should be provided. understanding not what is very, very important, and understanding not only legal issues, but also IT security issues. So the DPO is integral part of the organization, making her ideally placed to ensure compliance. This is not a formal position. Much depends on the DPO, but the compliance depends not only on the DPO, but also on each employee. And there is a mistake when appointing a DPO and expecting it alone will solve all the problems related with GDPR compliance. So this is a mistake, and DPO must help, consult, initiate, and etc. But compliance must be ensured through the whole organization, and every employee must contribute to the compliance. And the officer, data protection officers, should be more like a consultant advisor. But as I said, it's a mistake to appoint DPO and expect that DPO will solve all the problems. Okay, so here we have, today we will have several tasks. One task we will have now, and 3 tasks we will have after our part about data security, about personal data security. The first task is for warming up, let's say. The task, now let's start, for example, you can see a statement and several possible answers. And one or more answers may be correct. So one or more answers may be correct. This particular task, you need to provide the right answer from each table. I don't know how many tables you have today. I think 7. And this task should take up to 5 minutes. And if you take less time, we can discuss the answer sooner. So please read the task, and please indicate the correct answer or answers. So up to 5 minutes, and I will wait the answers from each of the table. And we can start from now, up to 5 minutes, and I will wait for the answer. So which answer is correct and why? I see. I hope you see the text clearly.
Jeigu jūs man leisite, gerbėmieji mūsų klausytojai seminaro, aš paprašyčiau mūsų 5-ojo stalo pateikti savo siūlomus atsakymų variantus. Paprašysiu mūsų gerbiamo profesoriaus šiek tiek suteikti mums daugiau laiko dėl tiesiog techninių tokių sprendimų ir vertimo pateikimo mūsų gerbiamiems svečiams. Dėkoju labai, profesoriau.
Thank you very much, Professor.
So the answer from table 5 is the first one, yes? If I understand correctly.
Profesoriau, atsiprašau jūsų, kadangi mes susidūrėme su šiokiais tokiais techniniais vertimo nesklandumais, galbūt jūs pats galėtumėte išversti mums uždavinį šį taip pat ir į lietuvių kalbą. Ar galėčiau jūsų to paprašyti?
Ką tik tas buvo padaryta, bet aš galiu pakartoti. Reikėtų, taip?
Jeigu tai buvo atlikta ir visiems salėje yra aišku, tai viskas tada gerai.
You don't need to.
If I need to once again to translate to Lithuanian language, so please indicate. So this is a little tricky task, so please read carefully all the answers. And later I will explain why appropriate answer is correct and why other answers are not.
Aš matau, kad kolegos penktojo stalo tarėsi, bet noriu paklausti, ar jūs jau turite preliminarų atsakymą, ar jums dar reikėtų kelių minučių pasitarti?
And of course, not only please say which answer is correct, but why this answer is correct.
So do you hear me?
Yes.
Do you hear me?
Yes, I hear.
Okay.
I hear you.
So we discussed the question, and we are not very sure, but we think that it might be the answer number 2 and number 4.
Yeah. So the option is number 2 and number 4. Yes. Which table it was? Could you please?
Jeigu aš gerai matau, tai yra penktasis stalas.
Thank you. Are there any other opinions about the correct answers from other tables?
Kadangi turime pakankamai ribotą laiką, prašysime gal jūsų, profesoriau, tada pakomentuoti atsakymų variantą.
Okay, so of course I see that our time is limited today. So the correct answer is the first answer. The controller and shall be responsible for and be able to demonstrate compliance with principles relating to data processing of personal data. Why this answer is correct? If you remember, one of the slides on accountability mentioned that 2 things were important to be responsible for compliance and the ability to demonstrate compliance. So responsible and ability to demonstrate compliance. But the first answer is correct because it mentions both of these elements. For what reasons other answers are not correct? For example, the second and third and fourth are inappropriate due to the fact that the controller and the processors, as already was mentioned, do not have equivalent accountability requirements. So the scope of accountability requirements for the controller and the processor varies. Therefore, the only correct answer is the first answer. So, okay, can we move further with personal data security until the break? We still have about 12 minutes. And after that, we will continue. So personal data security, it's a very important part of GDPR related personal data security. And we can start with the fact that the basis of both personal data security and cyber security is so-called CIA triad. What does it mean? This triad consists of three parts: availability, integrity, and confidentiality. Here we have some explanations. What does confidentiality, availability, integrity mean? In practice, all the measures implemented to ensure confidentiality are designed to prevent the information, personal data from being accessed by unauthorized individuals, by unauthorized entities or processes, while ensuring that authorized individual entities have access to it. An example would be sending personal data outside to the wrong email address. So in case of sending personal data, email with personal data to wrong email address, it already is treated like personal data security breach according to the GDPR. The second one, integrity, implies maintaining the consistency, accuracy, and trustworthiness of information, personal data over the entire life cycle. So data must not be changed in transit, and measures must be undertaken to ensure that data cannot be altered by unauthorized individuals, entities, or processes. From practical point of view, this means that data cannot be modified in an unauthorized way or in undetected manner. And availability, this means that the system, for example, information system used to store or process information, personal data, as well information communication channels are all functioning correctly. An example could be the DOS attacks that result in a loss of access to personal data. DDoS, I can repeat, DDoS attacks that result in a loss of access to personal data. In the area of information security, there are several standards and frameworks providing for different types of controls and following the CIA triad. So the most known and widely employed is standard ISO number 27000 family. So usually data controllers or data processors in practice implement one of the standards or several standards from this family, number 27000. And we will see later a breach of at least one of these elements is considered or could be considered as a breach of personal data security. So, and of course, several elements can be breached during the same time, during the same, for example, attack or etc. So this is the base of personal data security as well as cybersecurity. And part of Article 5 of GDPR, Part F, says that personal data should be processed in a manner that ensures appropriate security of personal data, including protection from unauthorized or unlawful processing and against accident and loss, destruction or damage using appropriate technical or organizational measures. As we can see, the CIA triad is integrated in this principle. And security measures should be appropriate, not maximum in every case, but should be appropriate to risks that are related with processing of personal data. And in GDPR, we have one main article, article number 32, security of processing. And it should be noted that the regulation does not lay down specific security measures, but sets out rather criteria. We see that security measures should be based on a number of criteria, for example, nature of personal data, scope, context, purposes of processing it, etc. And one of which is so-called risk-based approach. So criteria regarding risk and the list of security measures we can see in this article is not exhaustive. It's like example what security measures could be implemented. For example, pseudonymization or encryption of personal data, or regular testing, assessing and evaluating of effectiveness of technical and organizational measures. And it's very important that regulation does not allow to national states to implement appropriate legal acts regulating security of personal data. Therefore, recommendations are often issued in national states, which set out detailed security measures. This is the case also in Lithuania. In Lithuania, we have separate recommendations regarding IT security measures and risk assessment. And the main issue is risk, so-called risk-based approach. As I already told, technical and organizational measures must be adequate to the risk, and processing of personal data must assess nature, volume, context, purposes, and of course, close relations with data protection impact assessment. In this case, risks are also assessed, but usually in the context of specific project or information system, and risks are assessed more broadly, not just only security risk. So risk assessment in case of data protection impact assessment is much broader than only security risk assessment. Here we have traditional risk assessment methodology coming from ISO standards, also ENISA, European Network and Information Security Agency documents. And the methodology is very simple. We should identify, of course, threats and threat occurrence probability. Then we should identify impact, and at the end we receive risk level. For example, if we have threat occurrence probability at low level and impact high or very high, at the end we receive a high level of risk. So this methodology is using in every case when evaluating security risks or evaluating risk related with some project while doing data protection impact assessment. This picture maybe will be more clear. We have 4 options in this picture, and in the first case, it is likely that the person will jump over the hollow, but even if he does not jump, the impact will be small, such as getting his feet wet, for example. It means that high probability and low impact. In the second case, we see low in both cases. In the third one means that also the time chances of not jumping are low, but if this person don't jump over the hollow, he will probably have major problems. There can be a serious, for example, health risks. It means low probability and high impact. And in the last case, we have high probability and high impact. The same is with the risk to privacy and personal data processing. And the methodologies for risk assessment and security measures in particularly are based on this principle. Okay, and I can see that we have 4 p.m. On Lithuanian time. And I think according to agenda, it should be a break for half an hour, if I'm correct.
Taip, dėkoju Jums tada, profesoriau, už Jūsų pirmąją pranešimo dalį ir skelbiame kavos pertrauką, o po jos vėl susitiksime.
Okay, we will meet in half an hour.
Taigi, tęsėme savo seminarą
Ladies and
tema
gentlemen, we
duomenų
continue
apsauga
our
ir
seminar on
kviečiame
data protection
profesorių
and we
pratęsti
invite
savo
Professor
pranešimą.
Stutilis to continue with his
Thank you.
presentation.
I will share my screen. So we talked about basic principles of risk assessment, and we can move further. I will shorten some slides in order not to be far behind of time. So data mapping, when we talk about data mapping, without data mapping, data inventory, you won't know exactly which system process personal data, where it comes from, and to whom is provided, and etc. Therefore, security measures in such case may be difficult to determine precisely. So we have to have all answers, why personal data is processed, what personal data, for what purposes, what are legal grounds, how personal data are processed, for how long, and etc. And now we have security risk management cycle, risk management for personal data, and we can see that we should begin from defining the context of personal data processing. It means data mapping. After that, we identify relevant security threats. Of course, we should calculate risk according to mentioned methodology. We should select appropriate measures and implement certain measures. And it's very important to mention that security risks must be assessed for every information system or for every purpose of processing of personal data. And after that, specific security measures are identified. And here we have organizational security measures and technical security measures. So security measures basically can be divided into two categories. And we can see organizational security measures and types of such measures. For example, we should have security policy and procedures. We should have roles and responsibilities regarding access to personal data, including access control policy. We should have control. We should control data processors. We should have training, annual training, and etc. Of course, confidentiality of personnel, it's very important. All employees should sign agreements, for example, regarding confidentiality of personal data, etc. And technical measures are related with more technical issues. For example, if we have access from mobile portable devices to personal data, we should have technical security measures regarding mobile devices. Of course, physical security is very important. At the end, I will provide some simple measures. Let's call it like security hygiene, and some practical issues of organizational security measures. So let's discuss about practical examples, and I think it will be much more clear. For example, weak control of processors, lack of control of processors, or there is no agreements with data processors, failure to conduct cybersecurity training. Usually in the training material, we can see, for example, what are the basic principles, or what are the data breach procedure, etc., etc. But it's very important to include material about personal data security, what we should do or not to do, how to implement, how to implement, and how to secure our organization and personal data. Another issue: no rules on password usage or no documented password policy. It's weakness in backup or business continuity policies. For example, if we have incident with ransomware, for example, when data is encrypted and we do not have any backups, so we are in trouble in this case. Weakness in security management policy of IT providers, no mobile policy, mobile devices, policy, lack of emergency personal data recovery procedures, unencrypted laptops, absence of locks in the server, and etc., etc. So there are a lot of issues with organizational security measures. And some practical issues with technical measures. Of course, usually technical people are responsible for those measures, but let's see to the list. For example, personal data is not deleted after the term after the term for processing ends. Personal data, for example, drawbacks related to access control, almost no access control, or administrator access is not fixed. Employees changing positions may have old access to the systems. No user inventory is performed, and needs to know principle, access principle is not implemented, password not changed periodically or changed too infrequently, and etc., etc. So there are, of course, we should look to security measures very seriously, because according to European practice, quite a lot of fines are related with non-implementation of security measures. And we can see also automatic tool provided by ENISA, which helps us to conduct security risk evaluation regarding security measures, and to detect what security measures are important and should be implemented. So instead of mechanical work, we can use this automatic tool, and these are at the left. These are we can start from data inventory. After that, we identify risks, indicate impact, and etc., etc. So at the end, we can export the file with the list of recommended security measures, and to have evidence of compliance according to GDPR. Of course, this automatic tool can be used in case of data protection impact assessments, when we want to evaluate personal data security side. So this is very useful automatic tool, and I recommend to use in practice. And now we have personal data breaches, several slides on personal data breaches. And for example, the biggest data breach in Lithuania so far has occurred with the car sharing company, when data from over 100,000 users has been leaked, and the company was fined by the largest fine so far in Lithuania, 110,000 euros. So it's very important to understand what security breach is and what to do in the event of security breach and how to prevent such breach. We can see definition. What is treated as a security breach? It means a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data transmitted, stored, or otherwise processed. It's also related with mentioned C8 triad. And possible consequences can vary from physical, material, non-material damage to data subjects, for example, loss of control over their personal data. As I said, example could be the personal data sent to person which is not in the list of notary partners, etc. Financial loss, unauthorized damage to reputation, etc., etc. So a lot of possible consequences could be in case of data breach. And data breach can include access by unauthorized third party, sending, as I said, personal data to incorrect recipient, loss of availability of personal data. And example could be infection by ransomware, so-called ransomware. It's a malicious software which encrypts the controller's data until ransom is paid. This is very usual risk in Lithuania as well. And this could lead to a temporary loss of availability if the data can't be restored from backup. However, a network intrusion still occurred, and notification could be required if the incident is qualified as confidentiality breach. Please remember, as I said, one of the CIA triad components breach could be treated as security breach. So we have confidentiality, availability, and so incident may be qualified as confidentiality breach. And this presents risks to rights and freedoms of data subjects. In this case, breach should be reported to data protection inspectorate, and in some cases to data subjects. This is questionnaire who can help us to understand essential aspects you need to ensure in the preparation stage. For example, we know how to recognize personal data breach. Yes, we understand what personal breach isn't only a loss or theft of personal data. We have prepared response plan in the case of personal data breach. We have allocated responsibility for managing data breaches. Yes, and our staff know how to escalate a security incident. So every employee must be aware that he or she must report the breach to his or her supervisor or responsible person. This is a very important rule. And as I said, breaches could be connected with one of CIA triad elements. Responding to personal data breach, also the self-questionnaire. So we have in place process to assess the likely risks to individuals. We have process to inform affected individuals. So there should be clear rules, clear processes to what to do if data breach occurs. And the term to inform, for example, Lithuania State Data Protection Inspectorate is only 72 hours. If data breach occurs on Thursday evening, yes, so we have only 72 hours to inform supervisory authority about data breach. And of course, we should document all data breaches, even they don't need to be reported to supervisory authority. Here we can see recommendations from ENISA how to evaluate. So in practice, it's often asked how to assess the risk to data subject and how to decide whether breach should be reported to supervisory authority or whether breach should be reported to data subject or data subjects. And here is a methodology that can be used. Let's see an example. As we can see, the loss of the same personal data can be treated very differently according to context. For example, loss of names and telephone numbers can be treated very differently. First case, loss of, let's say, consumer data of supermarket. Yes, and in the worst scenario, case number 4, list includes names of people working for Secret Service. So according to context, data breach can be evaluated very differently. And statistics, some statistics from Lithuania this time. So 39% of personal security breach occurred due to human error. It's a statistics from 2001. What can we say? So the weakest part in ensuring the security of personal data is often the individual, not the systems, but individual. So that's why we are talking about social engineering, attacks, and etc. In practice, therefore, a number of measures need to be put in place to ensure that employees understand and acquire right skills regarding protection of personal data. For example, recommendations for employees on safe behavior in electronic working place, staff training, including the exam. It's very, very important thing to evaluate knowledge, yes, or after the training. Of course, internal communication before, at the time of the data breach and after the data breach, for example, lessons learned. And of course, we can speak about checks on how procedures work in practice. Without an inspection or checks, you can't find out if the staff has actually understands the material and if acquired the required skills in practice. So inspections or checks how it works in practice are very important. For example, we can send some misleading emails to our employees and check how they react to those emails. And some recommendations on safe behavior in electronic workplace. Security of personal data, to my opinion, starts from simple things. In practice, there are basic safety requirements, also known as safety hygiene. So, for example, create a strong password and update it regularly. What was the problem with this biggest data leak case in Lithuania with car sharing company? Yes, data was leaked, including passwords. But what was the main problem with that? So the passwords of data subjects was very simple, and they used the same password for several cases. So the data leak, when data was became public, yes, those passwords were used by criminals in other information systems, because data subject usually uses the same passwords in several systems in electronic shop, in banking system, etc., etc. Do not open emails on unknown origin letters or references. Please show those emails to IT person. Do not allow unauthorized personnel to access documents, databases, information system, or devices interested to you. Keep documents, including personal data in workplace, only in places inaccessible to outsiders. Do not leave unauthorized persons alone in your workplace. Use only licensed software. Do not install any non-operational programs in your main computers, and etc., etc. So these requirements, it's like a safety hygiene, and we should start from such simple things, simple steps in practice. And now we have several tasks. Of course, our time is limited, so maybe we should start from the first task. And I will read, and I will let's say I will provide the right answers. Why one or another answer is correct or not correct. And the task is actions in case of personal data breach according to the GDPR in case of personal data breach. The first option, the controller and the processor shall without undue delay and where feasible, not later than in 72 hours after having become aware of a breach, notify it to supervisory authority unless the personal data breach is unlikely to result in a high risk to freedoms of natural persons. Another option, the processor shall notify the controller without undue delay after becoming aware of personal data breach. The third option, the controller and the processor shall without undue delay and where feasible, not later than 72 hours, communicate the personal data breach to the data subject. Another option, the controller without undue delay, where feasible, not later than 72 hours after having become aware of a breach, notify it to the supervisory authority, unless the personal data breach is unlikely to result in high risk to data subjects. And the last, none of the above the answers are right answer. So in case of personal data breach, the controller and the processor have separate roles. The controller is responsible for notifying data subjects and or supervisory authority. And the processor must inform the controller about the breach, only to inform controller about the breach. And that's all. But of course, after that, to help, to investigate the breach, and etc., etc. But the data processor alone is not authorized to take any other actions with data subjects or supervisory authority. Therefore, the correct answers are two, the second and the fourth one. The second one, the processor shall notify controller without undue delay after becoming aware of personal data breach. And the fourth one, the controller should take some measures informing supervisory authority and, if needed, also data subject in case of there are high risk to data subject rights. So right answers are in and now the task I know you have this task printed. Theft in notary's office, and the fabula is computers of a notary and his office staff were stolen, which stored personal data, by the way. So the data on the disks of stolen computers had been encrypted, password protected, and the data is backed up. So the question is, what steps must a notary take in the case of theft? And there are four options. So theft in notary office, the computers were encrypted and personal data were backed. What steps the notary should take in case of this data breach? So please read the answers, and you shall indicate the right answer. Just indicate the right answer. So please discuss among your colleagues and please give me the right answer.
Jei dalyviai salėje man neprieštarautų ir pritartų, tai siūlyčiau, jog teisingi atsakymai yra pirmasis ir trečiasis, o antrasis ir ketvirtasis atsakymai yra neteisingi vien tik dėl to, jog abiejose atsakymuose yra nurodyta, jog apie įvykį nereiktų pranešti asmens duomenų apsaugos inspekcijai. Tai galbūt mūsų būtų toks atsakymas, koks būtų jūsų vertinimas, profesoriau.
Professor, what do you think about it?
So let's start from encryption process. So strong encryption practically protects data from unauthorized access. So data subjects are not considered to be at risk in this case. When we have encrypted computers, there is no risk to data subject. Of course, I am talking about strong encryption. Accordingly, neither the supervisor authority nor the data subjects need to be notified. However, the police, of course, must be informed about suspected crime, and therefore the correct answer should be the fourth answer. But let's discuss. I know we almost have no time, but let's discuss the second task. I will read only the fabula. So the notary leaves his car at the supermarket, and a work computer with personal data remains on the back seat of the car. When a window is broken, a thief steals a computer. Also, the disk of the stolen computer was not encrypted, but the computer was protected by biometrical technology. It means that computer could be activated only with fingerprint of the notary, for example. As you know, biometrics in the case of fingerprint are unique, and it's practically impossible to lose this data like a password. And the question is, what actions must a notary take in the event of that computer theft? So no encryption, but protection using biometrical technology. In this case, after stealing the computer, the fingerprint reader that is in the computer can be mechanically disconnected from the computer and personal data can be accessed if it's not additionally protected, for example, encrypted. So in this case, therefore, the correct answer is the third answer. Information of the police also must inform supervisory authority and data subject, and if there is high risk to data subject. So we can think that biometrical technology is very safe, but in practice, in this case, when the fingerprint reader can be mechanically disconnected, so it's not a safe way to protect personal data. So in case of theft, the notary should inform supervisory authority as well as police. I don't know if is everything clear about this task, and if I explained.
Yes, thank you very much for your comment.
And I think we have 5 p.m. Lithuanian time, and then it should be also YouTube material about personal data breaches from colleagues from Latvia, if I correct.
Yes, Professor, you are absolutely right. Thank you very much for your presentation. And now I would like everyone to invite to watch the video material on data protection.
Thank you all for your attention.
Le responsable du traitement et son sous-traitant sont tenus de coopérer avec l'autorité de protection des données. La coopération a lieu à la demande de l'autorité de protection des données, mais peut également intervenir de manière proactive. Par exemple, dans le cadre de la notification des violations de données à caractère personnel, plus communément appelées les fuites de données.
Une violation de données à caractère personnel consiste en toute atteinte aux données entraînant de manière accidentelle ou illicite la destruction, la perte, l'altération, la divulgation non autorisée de telles données ou l'accès non autorisé à celles-ci. Les personnes concernées sont, au niveau d'une étude notarielle, les parties aux actes authentiques ou encore les collaborateurs de l'étude. On parle ici de fuites de données relatives aux informations salariales, par exemple. Bien que le risque zéro n'existe pas, le notaire doit mettre en œuvre les mesures techniques et organisationnelles appropriées afin de garantir un niveau de sécurité approprié et éviter de la sorte la survenance d'une violation de données. Pour commencer, le notaire va rédiger un registre des traitements. Ce registre décrit les finalités poursuivies, le détail des catégories de données à caractère personnel, la liste des destinataires de données, etc. Ce registre va surtout être très intéressant et utile car il permet au responsable du traitement, donc le notaire, ou à son délégué à la protection des données, d'identifier les traitements qui pourraient impliquer des risques pour les droits et libertés des personnes concernées. Ainsi, les mesures appropriées à mettre en place afin de sécuriser les traitements de données sont bien plus facilement identifiables. Par exemple, le notaire s'assurera ou fera assurer par son fournisseur informatique que l'accès à Internet est sécurisé, que les logiciels antivirus des PC portables sont régulièrement mis à jour, que le système impose l'utilisation de mots de passe adéquats ou encore qu'une mise en veille automatique se déclenche automatiquement après un certain temps.
L'obligation de notification impose au notaire d'informer l'autorité de protection des données et les personnes concernées des cas de violation de données personnelles, selon les modalités définies aux articles 33 et 34 du RGPD. En cas de fuite de données confirmée, le notaire est tenu de notifier cette violation dans les meilleurs délais et, si possible, dans les 72 heures après en avoir pris connaissance. Sauf, bien entendu, si la violation n'est pas susceptible d'engendrer un risque pour les droits et libertés des personnes concernées. Lorsque le risque est élevé pour les droits et libertés, alors le notaire devra également notifier les personnes concernées de la violation de données à caractère personnel. Pour analyser ce risque élevé, il est nécessaire de prendre en compte le volume de données, la criticité des données, les catégories de personnes concernées.
Prenons le cas de la diffusion accidentelle de testaments sur Internet. Dans pareille situation, le notaire prendra contact avec l'autorité conformément à son obligation de notification de fuite de données. Il devra également avertir les personnes concernées par la fuite des données, car le risque d'atteinte à leurs droits et libertés est élevé.
Ladies and gentlemen, we move on to the last final section in our seminar. We will hear about the situation about GDPR in practice in Estonia and Latvia. The situation in Estonia will be covered by Katrin Sepp, assessor and advisor to the Chamber of Notaries of Estonia on legal matters. Madam Katrin Sepp, please join us. The floor is now yours.
Hello, can you hear me?
Yes, we can hear you.
Okay, thank you. Good afternoon and greetings from Tallinn. It has been a very interesting training day, but also quite intense. And as I am perfectly aware that I am one of the last speakers, my intervention is not going to be a long one. And I will just give you a brief overview of the Estonian notaries' practices when it comes to data protection in recent years. When I started preparing for today's presentation, I first reviewed what I had talked about at the data protection seminar in Vilnius in 2018. And what I discovered was that although the GDPR was new at the time, I was already quite optimistic then and believed that there was little cause for concern. First, Estonian data protection law, which existed before the regulation, was not significantly different from the GDPR rules. And secondly, our IT programs had already been designed to ensure data protection. And I'm happy to say that everything has indeed been working well in general, and it has been confirmed by the fact that although the number of complaints and other notifications filed with the Data Protection Inspectorate has been on rise in recent years, no complaints have been filed against notaries so far, and no information is known about the leakage of data from the notary offices. Nevertheless, some changes have taken place, and they mainly have to do with using IT systems and making inquiries to get data from registers. As many of you might know already, Estonian notaries use an IT system called e-notary as a tool for communicating with different registers, drawing up the authentic acts, archiving them, and so on. As the e-notary program is connected to at least 16 registers, getting the data from those is easy and could be made within a few clicks. But our goal in the past years has been to improve the system so that we could follow the principles of minimalism and purposefulness to the maximum extent. Thus, when a few years ago the notary or the notary's employee would get all the information stored in the population register about a person by clicking one button, now the person who makes the inquiry would have to choose what kind of information is needed for a specific transaction. Is it enough to just get the name, address, maybe information about the possible limitation of active legal capacity of the person, maybe the valid documents, or is it necessary to also get information on the person's relationships, and if so, which relationships? And I would say that this has been one of the most important developments regarding data protection. However, it is not only us who have been developing systems. The state has been doing the same. Estonian citizens have the possibility to keep an eye on who is accessing the data. This tool is called the data tracker, and it can be used via the citizen portal. In fact, the tool already existed before the GDPR, but the number of databases related to it has increased compared to 2018. For example, quite recently, citizens were given the opportunity to see who has accessed their real estate information in the land registry. As notaries are making at least 90,000 land registry inquiries per year, this change has, of course, affected us as well, as people are now asking the Chamber of Notaries why their information about the real estate has been accessed. The thing is that when using the data tracker, the register code of the Chamber of Notaries is displayed to the person. Thus, the person might not associate an inquiry with a certain notary's office. And if the question is sent to the chamber can find out the notary office that made the inquiry. Then the chamber replies to the person who made the request, saying that the inquiry was made in connection with a notarial act. And if necessary, the person can contact a certain notary office directly to specify the reason for making the inquiry. Like this, the use of data tracker is expected to lead to a considerable workload, both for the chamber and the notaries themselves, answering the citizens' requests. More so, as the system is unable to distinguish in connection of which owner the inquiry was made if one land plot, for example, has several owners. What makes the situation a bit puzzling is that the general data in the land register has been public and should be public according to Estonian law. Furthermore, the law prescribes that a notary does not need to prove the legitimate interest to access the land registry files. Thus, the question has arose whether the use of the data tracker service is justified and necessary at all. Unfortunately, the state did not discuss the implementation of this tool with the stakeholders. And if the above was primarily about the use of databases, I would also like to say a few words about how the information flows between the notary's offices and clients these days. And to be honest, there is not much change here in the recent years, as the contracts are still sent by email and in the usual Word file format. Although the Estonian ID card actually makes it possible to encrypt files relatively easily. People just don't bother decrypting them and probably don't consider data leakage to be such a significant threat. In other words, the issue is not that the notary offices are not willing to encrypt the documents, but the clients just don't want it. From the beginning of 2020, the self-service portal is in use, whereby logging in with an ID card, the client can book an appointment at the notary's office and send and receive information related to a transaction, including reading and commenting on the draft project, and all in one secure channel. but its use is also rather small, and regular email is still preferred. Since the beginning of 2020, the remote authentication program is also in use, which allows notaries to authenticate acts over web without the need for participants to appear at the notary's office. For safety, but also for convenience, the program was entirely and specifically developed for Estonian notaries and integrated in our pre-existing e-notary system. It includes all the components we need for remote authentication, logging in with ID card, video call, the ability to record the call, sharing the document, and digitally signing the act. Using the remote authentication has raised the question of who should be allowed access to the video call. The involvement of, for example, brokers, lawyers, or other third parties. Some notaries see no problem if all parties agree. Others do not allow this at all. Some apparently do it selectively. But I guess this is a more general question when it comes to data protection and has not to do with remote authentication specifically. I mean, not all notaries allow such third parties to be present at the signing of a transaction if it physically takes place in a notary office either. Thus, I guess I can say that in recent years, some old concerns have appeared in a new format, but although the remote authentication is for Estonian notaries the biggest change and challenge in recent years, data protection-wise, it maybe has not made that much difference. To finish, I would switch from what has been done to the future to see what maybe could be done next in regard of data protection. And where I think we could improve our regulations and systems is when it comes to deleting the data after the period prescribed by law. Although many authenticated acts are, according to our regulations, archived and kept in paper archive forever, like last wills, contracts, powers of attorneys, the data used for preparing the acts, like emails, are stored electronically, and they should only be kept for a period of 10 years. Currently, the system does not delete the information automatically. It must be done manually, but I think automation of these systems is something that should be investigated. And as a conclusion, I can say that looking back to the past few years, the changes have not been too intense, thanks to the work that had been done before. However, we have not been sitting on our hands either. The systems have been constantly improved, and I guess we will just have to continue being at the same time both conservative when it comes to preserving the data and our clients' interests, and innovative when using the new tools and technology for doing it. But thank you. That's all from me at the moment.
Thank you very much. And now I would like to give the floor to Aigar Skaupe, and he'll talk about the situation in Latvia. Aigar Skaupe is member of Latvian Sworn Notaries Council. He is a notary practicing in Riga. The floor is yours.
Dear colleagues, I'm always happy to be here in Vilnius. I'm happy to see that Vilnius is vibrant as always. It's developing, and you can see it just looking outside the window. And these days of uncertainty and restrictions, they make one recognize what a privilege it is and good feeling it is to be able to meet colleagues from Lithuania, from those from neighboring countries, and to exchange eyesight personally in presence. I even have a little lipstick mark on my mask, so it proves that we are really warm-hearted and nowhere humanity has disappeared during the pandemic. And going now to my presentation today, I would like to give you a little insight of applicable law in the field of data protection in Latvia concerning notaries, and also to point out some problems detected in the work of notaries in order to ensure correct application of data regulation. As you can see in this slide, data protection and the notariate might appear in three possible situations. The first and classical one, of course, is when the notary performs notarial duty, the notarial function. But then the other one is when the notary still does process data of the person, but it's not for the purposes of particular notarial function like certification or notarial act. These situations could be like consultations, drafting some draft of some application, a letter to the business partner, or application to some state institution. So there are many other activities notaries can do for the favor or for the interest of the client, but which is not regulated, particularly by law. So situation is a bit different from the first one. And then, of course, there is a council of, or the chamber of the notaries, which can be involved in data procession as well. And if we look at the legal scope of data protection for the notaries, then of course we should mention a general data protection regulation as a applicable, as the general rule of data protection, and that's European law applicable directly. And then, of course, there is notariate law, which regulates many procedural rules for notarial activities. But also there are various regulations of Cabinet of Ministers in particular fields of activities of the notary. Also, not only we have rules who regulate the activity of the notary, but of course also the chamber of the notary, because chamber of the notary can be also the person which works with the data of the client. And there are, for instance, specific regulations of how the Chamber of Notaries issue permission to a person to gather certain data from notaries' files. This can happen in the case if a person is not a participant of particular notarial act or certification, but the person still has provable and legal base for getting particular information or the document from the notary's files. And then there are also regulations for the Chamber of Notaries, how Chamber of the Notaries have to store data in those public registries which the holder or processor of data is Chamber of the Notaries itself. And let me mention another law, which I will go later and reflect to that in my presentation. This is anti-money laundering law, which does not provide any specific regulation on how to proceed with client due diligence, but it still affects the work of the notary in some other certain way. And let me show about the main legal act what regulates the notarial activities regarding data procession, and this is notariate law, and this prescribes that in the case if for the certification purposes or for the purposes of making a notarial act, person have to be identified, then certain list of data have to be obtained by the notary, verified by the notary, and at the end also entered into the certification text or notarial act. You can see there are 8, and some of them I highlighted in bold, and some of them I left unhighlighted. As you can see, all these data are collected, entered into the registry, and later on also shown in the notarial act, which is issued on hand to a client. As the consequence, not only the person itself or herself or himself or other participant of the same act or certification is able to see all data, but even other person to whom the act or certification will be later presented. All this process is legal, and no data procession is violated, since the notary only does what the law prescribes. Yet we have expressed concern ourselves in the Latvian Notarial Chamber already that these historically created requirements are no longer justified in the light and for the purpose of data protection. We see that certain data which are verified and entered into the registry of notarial activities should not be revealed in the certification text, which will be issued on hand for the client. And we have set the task for ourselves when the notariate law will be open for amendments. Notarial Chamber is ready to ask legislator to amend these stipulated particular requirements and probably eliminate these highlighted in a bold, not to be shown in the certification text anymore. And the data protection in the daily practice of the notary, I think, includes 3 basic principles which should be adopted in its notary's daily practice. We have heard already about them many times earlier today, so I will just highlight once more. So the notary shall never obtain the personal data to the extent exceeding necessity to discharge particular obligation. In order to ensure data protection in documents and its confidentiality, notaries should use only official electronic address specially designated for the notarial purposes, and would never use any home emails, no WhatsApp messages, no phone messages, and other tools for exchange with the documents. A notary shall not carry out data processing for a third party if so requested by the client just for the reasons of interest. Of course, if the person is interested to process her own data, then that's not the question. But the question would be that you have the client and he said, okay, I'm a creditor and there is a debtor, and can you check data of the debtor, for instance, in the registry of properties, whether or not I would be able to claim to the person, and should I have some security against my claim? So that request should be never accepted and never processed such kind of data. In theory, everything might sound quite clear, but when it comes to practice, one can find that some questions still arise. Let me name few. Here is the one situation described. A notary has been requested to develop a draft of the contract. While making the draft contract, notary performs the verification of personal data in the public register. The client eventually cancels the visit or just don't appear in the office. A year later, what should notary do, of course? Data are processed, but there is nothing entered into notarial registry because nothing has happened. So the notary, taking into account requirements of data protection, would delete or data unnecessary to be kept. And the law does not prescribe that notary keeps these data being sent to the notary. But a year later, notary is asked by the client to justify the data checks carried out. So the notary has deleted all the information. I believe notary will be not able to remember by heart. But notary still has an obligation to explain the client why these data have been processed. So this is open question. Just think about it. I'm not the data protection specialist. I'm not ready to give a correct answer, but sometimes it's more important to give the correct question and then to think about it afterwards. Yep. So then let me tell you about the other problematic situation that might occur in the practice of the notary. The notary must carry out all the verification of that personal data in the corresponding amount of data in the registers. But what would be consequences to the notary if it happened that notary checked data to the greater extent just because of the mistake? Should notary somehow act? Should notary inform the client or data inspectorate or chamber of the notaries about mistake what have been taken? And I think that here I would like to comment a little bit. I think that if it just happened by the accident, okay, you are still responsible. And if the client will ask from you about this data collection, then you should need to explain to the client. But otherwise, if you know that this data you collected, it's only you who saw it, and it never went out from the office, and no third parties were be able to get any information of that, what you have gathered, then probably no consequences to the client have been made. And then you shouldn't do any particular action. But that's also only my personal point of view. Then the other situation that would be more interesting to point out, and this relates that anti-money laundering requirement. The client asks notary to delete his personal data and requests no longer store data because the notarial certification has happened, and these data submitted to the notary for these purposes are no longer needed. Still, notary might think that he is obliged to keep these documents brought by the client in the archive. And that would happen if notary performed anti-money laundering requirements. So the client might think that it's not necessary because the AML law, it does not prescribe directly which documents a client should bring down to the notarial office in order to prove source of money, for instance. But the notary might have internal system of control of regarding anti-money laundering, and this system might presume that notary have to keep obtain these data and keep these data in registries. So that would be collision of interests of the client from point of view of data regulation, and also at the other end, interests or obligations of the notary based on AML law, but which are not prescribed by law. These are internal system of the notary, which prescribes a notary to act in certain way. I still think personally that notary still would follow its own internal system, and not comply with the request of the client in this situation. But the court will definitely be the one who says the final word in this situation. And overall conclusions of my today's presentation are here. There are 5. I would like to say that since the notariate law specifies all the activities of the notary, it's always necessary that only reasonable amount of data are processed. That's the basic principle for the notarial activity. Then probably no breach of requirements for data protection would take place. The second, it would not be reasonable for each separate notary to hire individual data protection specialist for his or her own office. However, it would be advisable for the Council of the Notaries to hire at least one data protection specialist or to use him as outsourcing specialist, but for all the notaries, for all the system what a notarial chamber has. And notary must be careful and attentive for not to process unreasonable large amount of client data. And the Council of the Notaries has to ensure that the notary can obtain a certain amount of information in those registries that the notarial chamber holds. For instance, we have the registry of the last wills, we have the registry of the power of attorneys. So we always have to ensure that the notaries do not exceed by the accident and do not obtain too much information from that registry just by the accident. But notary will be able to look for the particular information for which notary is searching for. And we already have done such checkup of our internal systems in the Chamber of the Notary, and we should pay a great attention to that. And if notariate law or other special law does not provide for the notary's obligation to keep the client data, then in all these cases, these data must be deleted with no delay and in due time. And thank you very much. And I believe it was a hard and long day. And I'm sorry that I maybe exceeded a little bit my time left for the presentation. And we'll be happy to meet you everywhere in the presence, Vilnius or other city again. Thank you.
Dėkojame mūsų gerbiamam pranešėjui. Labai dėkojame taip pat, kad pas mus atvykote į Vilnių.
Ačiū for having come to Vilnius. Thank you very much. So, by information on personal data protection in Estonia and Latvia, we complete our seminar. We are grateful to all the speakers who have contributed to refreshing our memory on the history and the legal regulation on personal data protection. Thanks to them, we also have covered practical aspects that are relevant for the work of every notary. We equally thank all the participants of the seminar for having taken their time to study the conceptual and practical matters relating to personal data protection. We hope that the knowledge received during the seminar will be helpful. As Professor Štitilis has said, research and institutions working in data protection demonstrate that the human factor is among the key factors that lead to personal data breaches and cyber threats. Therefore, constant improvement of qualifications in the field of personal data protection and cybersecurity is an inevitable duty of every notary and notary's assistant. In hopes for the continuation of your consistent professional development on personal data protection, we look forward to your future participation in other trainings under the Training 4 project co-organized by the Lithuanian Chamber of Notaries and the Council of the Notariates of the European Union. Thank you very much once again to every participant, and see you again next time.